Good morning, everybody. Happy Wednesday. Welcome to TCF Live. My name is Dan. I'll be your guide on this 4-hour journey through Courtlandia. But let's start our day with Magistrate Chisholm, see what's going on there.
Come on.
It's for the schedule.
Yes, sir.
Ms. Williams, you're going to have the opportunity to consult with Attorney Schreeman before you're arraigned this morning. You're going to see on the screen an invitation to join Breakout Room 1. When you join that, you'll be speaking with the attorney privately. The court is not party to your conversation with the attorney.
Okay.
So you should see it on your screen about now if you haven't already.
Morning, Your Honor.
Good morning. We've got Ms. Williams here, and she is in the breakout room.
Wonderful. Thank you.
Mr. Harry? Harry, please unmute yourself. Thank you.
Okay.
This is citation 26RO00249. You were cited on the 12th of January for improper lane use in the area of 11 Mile Road in Center Street in Royal Oak. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
I would like to admit responsibility with an explanation.
And what is that, please?
I had been driving for 5-6 hours and it was late at night. I was looking for somewhere to eat. And so I was close to Royal Oak and there was a restaurant that was open. And I'm not familiar with Royal Oak and its streets. So I was just trying to find that place to eat. And so I was driving, I guess I had missed it. And I turned on my turn signal to find it. And I was driving slow. There was no other cars on the road. And so I got pulled over. I explained this to the officer, but he obviously, like I said, I am responsible because I should have known, but I didn't know the proper lane usages.
Is there anything you want to add to this, officer?
Yeah, Magistrate, I can make a motion to change the citation to impeding traffic.
Okay. Mr. Harry, what the officer's motion does for you is it takes it out of the realm of Secretary of State points. Do you have any objection to amending this to impeding?
No, thank you.
Impeding without a crash carries a fine of $175. That amount can be paid online or by mail, or if you choose, you could come and pay it at the courthouse counter, whatever works for you.
Okay.
Yeah. Have a good day, sir. No points.
Thank you. Bye.
have Marcus Sutherland. This is citation 26RO00797. Mr. Sutherland, you were cited on the 11th of February about 1:30 in the morning. You were cited for things, but you've taken care of the defective equipment, so what's left is the expired plates. So you were cited for driving on expired plates. When did you get the new plates or tabs?
I don't have the exact date, Your Honor, but
You have the registration with you?
if you could give me like 1 minute, I can easily grab it for you. I have the new tabs on my license plate right now.
Okay, do you have the receipt with you?
No, not on me. Everything's in my car right now. The actual
Why don't you get the
registration.
registration then?
Okay, 1 second. Thank you.
Okay, somebody's got their initials as their screen name, so let's see who AK is. AK, what is your name?
Hello, Judge. It's Alexandra Dalia.
What is your last name, please?
Dalia.
Fortalia?
Yeah.
Your ticket is 26RO00525. You were cited displaying a traffic control device back on the 28th of January on 12:20 in the morning, 12 Mile and Campbell in Royal. You can admit or deny responsibility for that infraction, or you can admit responsibility with an explanation. How do you wish to proceed?
I need to do an explanation, and no, I'm not agreeing with the officer, please.
So you're denying responsibility for that
Yeah.
infraction.
Correct.
You'd raise your right hands, please. Do you swear or affirm that the testimony you are about to give in this matter will be the truth?
Yes.
Okay, the officer will testify first, please.
Magistrate, I observed the vehicle traveling eastbound 12 Mile, run a solid red light through Campbell. It was also captured on dash camera, if you would like me to show that.
You want to show it?
I can pull it up right now.
Sure.
Just, if you could, Magistrate, just let me know if you can see the screen share. Magistrate, can you see the screen share?
Yeah.
Can you see this right here, Magistrate? It's up.
There's no indication that it's trying to turn on. There you go.
Is it up now?
Yes.
Okay.
So you're northbound on Campbell, but approaching 12 Mile Road here.
Correct.
Okay.
And right there, the light just turned red, right there. And then the traffic stop was initiated.
traffic stop was initiated on 12 mile. Can you back it up to the intersection again?
Yes.
Okay. The car was going eastbound on 12 mile,
Correct.
and we see the car enter the intersection from the west going east. And it appears that the light for northbound Campbell is red.
Correct.
Okay, what color was the light for eastbound 12 mile?
It was red, Magistrate. I don't know if you could see the video or not from the angle. It is a little blurry. The light was red before she entered the intersection.
Can you go back to it?
Yes, Magistrate.
Are you able to stop it? Okay, so it's clearly red for northbound.
Yes, and the light for eastbound and westbound is yellow right now.
Oh, I see that.
And then it just turned red right there. She hasn't entered the intersection yet. It is now solid red, proceeds through the intersection. And then the northbound left turn lane had a green light before she was out of the intersection.
And this has a delayed green, so it's red for both sides for about a second or a second and a half.
Correct, Magistrate.
Okay. And looking at it again, I could see the light for eastbound traffic.
Yes.
Okay, thank you.
Yes.
Ms. Fortalia,
Yes.
it's your turn, ma'am.
So, Judge, I entered when the light was yellow. And again, if the officer please can see how much I was going through, I was very slow. I don't know if it catches very slow. So for somebody to speed on the red light, it should be very fast. I was literally slow. And at that time, even though now is March, at that time of the incident, we were experiencing the winter storm, and it was ice on the street, ice everywhere. And I remember telling the officer I couldn't stop. For me to stop right, like literally a break, like hard break, it was very dangerous. I tried to stop. And again, when I tried to stop, it was yellow and the car just went through. I stopped on the side of the road trying to explain to officer. He was like, you know what? I'm still gonna give you a ticket. I was like, kids were there in the car. I was not speeding. I was not doing the hard break was even more dangerous because ice on the street. I'm not a
Ma'am,
speeder. I
Were you
was
able
not
to see
racing.
the tape?
The tape?
Were you able to see the film that the officer showed?
Yeah.
Did you
And
not
then-
see your car going through a red light?
So I'm trying to explain.
The light turned
Sometimes
red
when you
for
have
you.
to stop,
The light turned red for you before you entered the intersection.
I couldn't
Speed
stop.
limit
That's what
on
I'm
12
saying.
mile there is 35 miles an hour. A light is amber for at least 1 second for every 10 miles per hour of the speed limit. That light had been amber for you before you got to the intersection. It was at least 4 seconds since the light turned amber because it had already turned red before you crossed the crossbar.
I agree.
Crossbar
I'm trying
comes
to
before-
explain. No,
Well, ma'am.
Judge, I'm trying.
You're saying that you agree, but you're explaining it away. It doesn't matter if the ice is on the road. It doesn't matter if it's raining. You have to stop for a red light.
No,
You didn't-
absolutely. But when stopping, it's way more dangerous. That's what I'm saying. When I
No, it's not.
saw,
Dangerous. It's more dangerous
when
to
I
go
was
through a
try-
red light. There was
Okay,
nobody
maybe-
behind you, ma'am. The film
I know,
shows
please.
there's nobody
Yeah,
behind
just
you.
just 1 second, please. So I was trying to stop when it's yellow already. I was preparing to stop. If you see on the camera, I don't know if you can literally see that position, I was trying to stop, and meanwhile, while I was stopping, the car was not stopping because of the ice on the street. And then the intersection was not stopped right there. It's a little bit, you know what I mean? There are some stops right there, and there are some gaps. And then from the time I stopped and until to the end of that section was a little bit more than usual. So a big intersection. I mean, I was trying to stop.
Standard intersection, ma'am.
Huh?
It's a standard intersection. There's 2 lanes going all 4 directions, and there is a left turn lane.
That's what I'm saying.
Standard.
When I first pressed the brake till to the other side of the road, it looked like I passed on that red light, but I didn't. I was trying
You
to
did.
stop ahead of
You
time, but I
did.
couldn't.
Ma'am,
Huh?
you're explaining what happened by saying that you couldn't stop. But the bottom
Because of
line
the
is you
ice.
couldn't.
Yeah, because of the ice. Because sometimes it
It doesn't matter if it's because of the
Couldn't.
ice. You're supposed to drive at a speed that you can drive safely, that you can stop safely in time. If you're driving too fast to stop at a red light,
Oh
that
no, I was
doesn't
not
mean you
fast
don't-
at all.
you
I'm
work
telling
too
you,
fast. You told me you couldn't stop. If you can't stop, you're driving too fast.
no, my car couldn't stop.
Don't
not
tell me
me.
no.
The car couldn't stop, not
No,
me.
you're the driver. It's not the car, it's the driver.
But how many accidents is just because of the car? They couldn't stop of the ice. They couldn't the brake.
None. There was no crash there. There was no accident there.
You have to see my car. It goes
I
straight on
did
the
see
stop.
your car go right through the red light.
I know, but you see
You
all the
know
way
that.
when
Okay, the discussion's over. The fine
no,
is
I'm trying to explain. It was
$130.
not my fault. That's what I'm saying.
It is your fault. If you're the driver, you're responsible for what happens.
I'm telling
Everybody
you,
on the road shares the same weather. Everybody on the road shares the same visibility. They all share the same surface conditions. It's your job as a driver to accommodate your approach to driving to the conditions that exist then and there. If you go
I'm not
through a
trying
red
to
light, you go
discuss.
through a red light.
Judge, I'm not trying to argue or anything. I'm trying
you
to
are.
give my version.
Your version doesn't comport with reality, ma'am. You ran a red light. Pay the ticket. It's $130.
Can we work on the points? I don't want to lose any point, please.
The points don't come from the court, they come from the Secretary of State. I have nothing to do with the points. I can't make them better or worse. If I wanted to make them better, I couldn't. If I wanted to make them worse, I couldn't. They are what the Secretary of State says they are. The hearing is over, ma'am. The ticket needs to be paid.
So I will say this. Her argument is, if she had phrased it right, would probably have more validity. Intersections are often, I found anyways in all my years up in Michigan before I came to Arizona, can often be more unpredictable than the actual road that you're driving on. If she had phrased it like, look, as I approached the intersection, I started to brake, I realized how slippery that intersection was, and I judged that the safest move for me, as I saw no traffic coming in the other direction, was to go through. I could see that, and I could make that argument, but the way she was making it, I don't think it stuck. Good morning, everybody. TCF Live. It's a Wednesday. Good to have you here. Let's continue to ride with Magistrate for a little while.
Mr. Sutherland, Lynn, do you have the registration with you? Mr. Sutherland?
Yes, I have it right here.
Okay, can you put it in front of the camera, please?
I don't know if I might have to mess with it. I got the blur setting on right now.
Yeah, please take off the blur.
Okay, 1 second.
February 24th. And you got the ticket on February 11th, so 10 days later, 2 weeks later. Is there anything you want to add to this, officer?
Administrator, I'd like to make a motion to dismiss the ticket.
Okay, thank you. Mr. Sullivan, the ticket is dismissed thanks to the officer's motion.
Thank you. Thank you, Your Honor.
Designate Bailey.
Here.
All right. This is 26 RO 00972. You were ticketed for driving on expired plates back on the 18th of February. When did you get the new plates or tabs?
That same night.
Do you have a copy of the registration with you?
I do. It's right here.
Can you put it in front of the screen a little closer?
Yeah, I'm gonna turn the camera around so it's like not backwards.
0218. Same day. Is there a motion, officer?
Yes, Magistrate, I'd like to make a motion to dismiss the ticket.
Thank you. Ms. Bailey, you are good to go. The ticket is dismissed thanks to the officer's motion.
Thank you.
We'll call.
I'm free to
Oh,
leave.
you are good to go. You're good to go. Albert McGee has failed to appear. Default will enter at 8:54. Dorian Flanger has failed to appear. Default will enter at 8:54. Selena King has failed to appear. Default will enter at 8:54. And I believe that completes your docket, officer.
Magistrate, I had one more. I don't know if it got canceled. It was for MD Ahmed.
It didn't make my docket. They print my docket long after they print yours.
Okay,
And something happened in the middle. I don't know.
yeah, I'm sure there was something. I was just double checking with you.
He may have paid, he may have set it for a formal.
Okay,
Okay.
am I all set then,
You were
Magistrate?
good to go. Thank you.
All right, have a good day, Magistrate.
You too. Then we've got Mr. Schreeman and Ms. Williams. This is 25-01956. People versus Angel Saray, Canty Williams.
Good. Your Honor, this is the Essence Williams, not Angel Canty Williams. I think they're back-to-back Williams cases.
Right. And this is Essence Williams. This file is 26-00273. People of the City of Berkeley versus Essence Alana Williams.
Good morning, Your Honor. Joe Schreeman on behalf of Miss Williams, who is present via Zoom. Miss Williams, can you state your name for the record?
Essence Williams, hello.
Thank you. Your Honor, this is the date and time for initial arraignment. My client's being charged with 1 count of reckless driving as well as a civil ticket of no proof of insurance. I've had a chance to go over the charges with my client as well as her constitutional rights. At this time, we would waive formal reading. We would agree to participate via Zoom today and ask the court to enter a not guilty plea on Miss Williams' behalf. Again, that's a not guilty plea. Set this for a formal pretrial in front of Judge Kolakowski. Miss Williams has also indicated that she does wish for MIDC counsel to stay on for the pendency of this case. And I do have an updated address and phone number and email for the court. I can put in the chat or tell the court right now.
Why don't you just tell us?
Okay, her mailing address is 32.
Well, this is a good opportunity to move along since we try to protect information as much as possible. Doesn't always work, but sometimes we try. Let's stay in Michigan, but let's go over to Allegan. Say good morning to Judge Scoselis. Or not. Never fails. Several times a week, you go to a judge, and the next thing they do is cut their feed. All right, Lake County, Judge O'Donnell. Try that.
An accident, it wasn't knowing. Could I speak for just a moment on that point, Your Honor?
I do actually think that if his perception that it was an accident that he hit him, I do think that would fall under the knowingly, because the knowingly refers to making the action knowingly.
I mean,
It's not an intent.
see, here's how this stuff goes, okay, in a situation like this, as you well know, 'cause you've been doing this a long time.
Yes, sir.
Okay? If I accept his guilty plea, then when we come back on May 8th, we're gonna have an argument about what the sentence should be, because he's gonna tell me that he really didn't do it, okay? This is how this generally goes. So, if you didn't do this stuff, I don't know why you're pleading guilty to it. Other than to get it over with, which isn't a good reason to get a felony conviction.
Nothing I can do. I put myself in that situation. I don't know. I'm gonna plead guilty though. That's all right.
Okay, so you kicked C.O. Ellinger?
Yep.
Where'd you kick him?
They say in the face. I believe in the stomach, but
Okay. So you had this blanket over your head and you kicked?
yeah.
Okay. All right, what's your plea to count 1 assault, a felony 5?
Guilty.
What is your plea to the lesser included offense in count 2, the attempted harassment with a bodily substance, and misdemeanor 1?
Guilty, Your Honor.
Mr. Matthews?
Thank you, Your Honor. Prior to the hearing, I reviewed the written plea of guilty with Mr. Thomas. He indicated that he understood it and he intended to sign. Okay, put the date on that line, 3/25/26. Your signature on that line. Thank you. May I approach, Your Honor?
All right, Mr. Thomas, is this your signature on the written plea of guilty?
It is, Your Honor.
Did you sign it voluntarily?
Yeah, it did, Your Honor.
Do you want me to accept your written plea of guilty?
Yes, I do, Your Honor.
I'll accept the written plea of guilty. Defendant was present. Mr. Matthews advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. Will accept his plea of guilty and find him guilty of count 1 assault, a felony 5. And the lesser included offense in count 2, the attempted harassment with a bodily substance, a misdemeanor 1. I'll refer this for a pre-sentence report, a psychological evaluation, and victim impact statement. Sentencing will be May 8 at 10:30 a.m. and the bond is continued. Anything else, Mr. Geigerich?
Nothing, Your Honor. Thank you.
Mr. Matthews?
No, Your Honor. Thank you.
All right.
Okie dokie, quick and easy there. Let's go back to Michigan, Judge DiSanto.
Good morning, Your Honor. Attorney Corey Westmoreland appearing on behalf of Ms. Bond. Ms. Bond, would you please state your full name for the record?
Erica Bond.
All right, thank you. So we adjourned the show cause to today's date. Ms. Bond was here on February 11th, at which point this court adjourned it to today's date so we could see what defendant's employment status was. And then you were going to be submitting 30 job applications per week and submit proof of that every Friday. Did you do that?
Yes.
Okay,
She also did secure employment, Your Honor.
perfect. Was it from any of the 100 and some applications you submitted?
Actually, no. It was right down the street from my house at Shoppers Valley Market. I'm working in the deli now.
Okay, very good. All right, so how long have you been working?
I just started.
You started as in this morning?
No, like last week.
Okay,
I've only gotten 2 days of training so far.
all right. And so what, are you expecting your weekly paycheck will be, ma'am?
He hasn't even got that far with me.
Well, how much are you
I'm
working
making
per hour?
$14 an hour.
How many hours a week?
He hasn't given me a set schedule. I've only done 2 days. So.
Okay, are you hired full-time
Yeah,
or part-time?
I start full-time as of April 20th. I'll be on 5 days, but like this week I worked Monday, Tuesday.
Right.
And he's gonna call me, Friday and let me know my next day to come in. It's just not that busy right now because of the weather, so he said I'll be on 5 days come April 20th.
Interesting, that the grocery store isn't busy based on weather, but okay.
Yeah, it's because of the.
Oh, the
Across
business
the street.
Yeah, they're definitely busier for that. All right, so let's start payments May 15th. Okay, that'll give you a month or so of some full-time employment checks, as well as some checks of part-time payment. $50 a month, can you commit to doing that?
Yes.
If you can pay more, pay more.
Of course. I have a question though, could we maybe talk about the community service?
When you talk about the community service.
Talked about it last time, and that's why we adjourned it to see about getting my attorney asked for community service last time. And you adjourned it so I could put in the applications and everything, and then you said we would go over it again.
So what I will do is, once I see your good faith effort to pay on your balance, then we can readdress community service.
Okay.
Right? But I'm not, going to address it today, but I will, if after a few months or so of you making your minimum payments timely, and even if you make it a little bit extra, then you can certainly email in asking to convert some of that. You don't have to come back necessarily for a court date, but then you can, send an email indicating the judge said we could revisit it after some months of payment, timely payments, as to whether or not I can convert some of it to community service. Okay? All right. So we'll begin, your $50 per month, May 15th, which is a Friday. So if you're starting full-time the week of April 20th, you'll have at least one paycheck, possibly two, depending how you receive those, but you'll also be getting your part-time paychecks.
Okay, thank you so much.
Okay?
Thank you, Judge.
All right. Have a good day. You're welcome. Oops, so sorry. All right. We're on the record of the matter of Jody Millett, 232160.
Attorney Corey, welcome to the hearing that happened with my lap. With my lap, would you please state your full name?
Jody, my last.
All right. Good morning, Ms. Millett. You have a show cause here today because you have a balance of $730 that was not paid. And you did not respond to letters that were sent out. And so a show cause was scheduled. And so, counsel?
Yes, Your Honor. I did have an opportunity to speak with Ms. Mylott. She does acknowledge that she owes the money, I believe. But she made a payment last week to get herself back on track, and she's going to continue doing that.
Okay. How much are you paying per month, ma'am?
At first it was 10, 20, and then, I was gonna start doing 50 because I haven't had a job in a year, so,
But she has been working for DoorDash.
yes.
Okay. And so how much have you paid? You said you just made a payment. How much was that? Just so I know what your current balance
I
is.
think it was 20. It was 20.
Okay.
I was gonna make another one, but the car broke.
Okay, and so you're wanting to pay $50 per month
Yes.
and beginning when?
The middle of next month.
So we can do, so the middle of next month is on a Wednesday, which is April 15th. We can do that Friday, April 17th. Is that yes?
Yes.
Okay, if you'd like to get information, ma'am, you can stop at the window to get information about paying online, then you don't have to worry about making the trip in to make your payment.
Okay.
All right, thank you.
All right, thank you so much. Have a good day.
You as well.
Thank you.
This is the matter of Todd Steiger, 24938.
Your Honor, good morning, Richard T. Serrano, P33828, appearing on behalf of my client, here to my right. This is the date time set for show cause, Your Honor.
All right, sir, please keep your hands out of your pockets.
Sorry.
And just so we're clear, and I'm not sure if you work at a gym, but you're at court,
I know.
but that's what you wore to court.
I didn't have no nice clothes,
Okay,
Your Honor. And Todd Steiger.
all right, thank you. And counsel, today's is scheduled balance, the date scheduled for, show cause for your client's balance of $376.80.
Yes, Your Honor, he acknowledges that he has $20 only to pay today, but on monthly payments, once again, if the court would grant him that, what did
Okay.
you say, 25 a month you can afford? Is that what you said?
25 and 50.
Okay.
I know that you have another matter in the court, correct?
Yes, Your Honor.
Right, and you're on probation for that.
I'm out of bond. I'm not on probation.
You haven't sentenced you yet?
No.
No,
No,
sentencing's on the second.
that's correct. That's next week. Okay. And so, sir, are you working?
Yes, I'm working.
Where are you working again?
I work at 700.
Oh, that's right. Okay. So. You can pay $20 per month on this one?
Yes, yes, Your Honor.
Okay. When do you want to begin that, sir?
I can be doing it today.
Okay. All right, so beginning March 25th and the 25th of every month thereafter. Okay.
Yes, Your Honor.
And sir, just so you're aware, right? I'm not trying to judge you, so to speak, even though this is where I'm sitting, but
Yes, Your Honor.
just so you know, you can always go to the Salvation Army, to Value World, a thrift store even, and you can even just, not even just for court, but just for anything, and you can get some very nice clothing for inexpensive costs, just so you're aware. Not necessarily speaking for court purposes, but just for anything.
I
Because
understand.
I do know the cost of clothing is absurdly expensive for lack of quality.
I bought some nice ties from Salvation Army.
Yeah, so I'm just giving you that information. Okay, sir?
Yes, I understand. Thank you, Your Honor.
You're welcome. Okay, and so I'm going to have you stop at the window and you can make your first payment, and then you can even get information about paying online if you'd like.
Okay.
Okay, thank you. All right, we'll see you back next week on your other matter. Have a good day.
Thank you, Your Honor.
All these people are ready? Great. All right, we are on the record in the matter of Brandon Zarek, 2412902325571.
Your Honor, good morning, Richard T. Serrano, P33828, appearing on behalf of my client, appears to my right. This is the date and time set for show cause. Sir, please state your name.
Brandon Zarek.
Okay. Good morning. I'm sorry. I was thrown off for a moment. Do we have a sign language interpreter and they're on Zoom? Oh,
Interpreter.
I don't know how that's going to work, but
Which interpreter, which attorney is on the interpreter case?
okay, well, hold on. I've completely digressed and completely messed up Autumn's record here. Okay, Mr. Zarek, your name for the record, please.
Brandon Zarek.
Okay. I got thrown off when I saw it's an ASL interpreter, and so I started asking questions that have nothing to do with this case I'm on the record on right now. So we'll handle that in about 30 seconds here. All right, so today's the date scheduled for the show cause in this matter. You have two matters, sir. You owe $1,030 on the 2024 case, and you owe $1,216 on the 2023 case. And counsel.
Your Honor, my client tells me today that you could pay $100 toward each file if the court pleases. And that-
Bless you.
Pardon me?
I was
Oh,
saying bless you.
and if the court grants it, he would like to get on a payment program once again for $50 per month. He is working full-time, Your Honor, and excuse me, income should be a little bit more steady now, so he's gonna try to catch up and pay more even if he can. Is that correct, sir?
Yes, sir.
Okay, so sir, when's the last time you made a payment?
Roughly 2 weeks ago, about 200,
Okay, before that.
couple months, probably.
Okay, so sir, if something happens and you're unable to make a payment, email into the court. Right? So we don't think you just completely ghosted us,
Yeah, understood.
right? All right, so $100 today, and then you want to do 50, and that's on each case.
No, I was gonna do, oh, yeah, 200 today.
Right, 100 each case, and then $50 per month on each case, correct?
Yes, ma'am.
And you want to begin that when?
Yeah, next month.
For the middle of the month?
Okay,
Correct, sir.
April 17th?
Yeah.
That's a Friday, okay. Okay, stop at the window, sir, make those payments, and then you can even get information about paying online, okay?
Thank you.
All right, thank you. All right, let's go on the record. Let's go off the record. We're already on the record. Let's go off the record. Madam Interpreter? Okay, I'm so very confused how we're doing the sign language interpreter on Zoom. Madam Interpreter, good morning.
Good morning.
You're not able to be in person?
No, I was booked for this on Zoom.
I understand that. First, I'm having a very difficult time hearing you. You're very quiet. I'm just unsure how it's going to work with you on Zoom. Is her client in person?
Yes,
With your client in person?
we'd like an adjournment if that's the case, Your Honor. It's difficult enough to be able.
Well, hold on, counsel, please. Ma'am, where are you located? Are you located in the state of Michigan?
I'm in Michigan. I'm in Spring Lake, Grand Haven, Michigan.
Oh, wow. We're gonna try it on Zoom because that's a very expensive mileage that the court will have to pay for the sign language interpreter. I'm going to presume that that there is a shortage of sign language interpreters, which is why one from the west side of the state is zooming in.
All
Would
right.
that be accurate, ma'am?
Yes, Your Honor, that's accurate.
Okay. I just need for you to keep your volume up on your device because it's still very quiet.
Okay, I'm going to see if I can adjust it.
That's much better. I think you just have to get closer to your microphone.
Okay.
Your Honor, I'll zoom on, but
Well,
understand
no. You don't have to zoom out. Where's your client?
in the hallway.
Right. You don't have to zoom on. You and your client would be in person and your client would be looking up at the screen for the sign language interpreter.
Well, I understand that, Your Honor, but how am I supposed to communicate any plea offers, et cetera, to my client without her being?
Oh, yeah, that's a fair point. You're correct.
Your Honor,
I didn't know if your client had brought somebody with
That signs.
with him that sign language, that signs as well. So that's why I thought he had somebody with him, but not a certified interpreter.
Okay.
That's why I thought you wouldn't need to go onto Zoom, but
He does have someone with him, but I don't know the answer to that, but I'll find
Okay.
out.
that's fine. Either way, I'll have to have you go into the room. And then that way your client will be in there with you and he can then communicate with the interpreter.
That's
Yeah.
fine, Your Honor.
Your Honor, for the
Yes.
most part, professional standards call for a sign language interpreter between counsel and the client, and then another interpreter for proceedings.
Wait, I'm sorry, what?
Hear that?
So generally, in these situations, you have a sign language interpreter who interprets between counsel, the attorney, and the client. And then you have a separate interpreter that interprets for the proceedings.
Why do there have to be two different interpreters?
For confidentiality and to remain neutral in the proceedings. What takes place between counsel and the client is confidential. So there are times we don't follow that standard, but typically that is the professional standard. I am more than happy if it would be helpful to be on Zoom with counsel and the deaf person and then do proceedings. But technically it's more appropriate to have two interpreters.
Okay, well, I appreciate that learning piece today, because I would presume then if it's that would be the professional standard for all interpreters, and that's not been anything that's been disclosed to us. So that's why I was a bit caught off guard that way.
And Your Honor, if I may add, I'll speak to my client regarding confidentiality. That's certainly something that can be waived to effectuate our purpose, but
Okay.
find out.
Okay, so
Your
let's,
Honor,
yes,
Your Honor, may I also say that in the state of Michigan, there are rules and regulations and you have to be endorsed for
right.
legal work. So that's another thing to take into consideration if you have an endorsement with the state of Michigan.
Oh, no, we're very much aware of that, Madam Interpreter. I wasn't aware of the need for the second interpreter, for that purpose. So let's, so here we are. Well, we're gonna have to not do the ones in the back right now. Did you already speak to the people in the back? Are those yours?
I've spoken to nobody in custody, but I do have
Okay.
Wilcox is in prison, Your Honor. So if we could dispense of that before I go back to.
Is he on Zoom already?
He was, yes, he's waiting. I spoke to him. He's ready to go.
Oh, there he is. Okay, so he's got to come back out to the main session. Okay, let's handle Mr. Wilcox then.
All right.
And then I'll put you in a breakout room with the.
Mr. Wilcox in the back with Bobby right now.
Oh, that's Susan. Okay, good. Because I was like, well, we have
That'll work.
a big time constraint here with Mr. Serrano then. All right. Okay, do you have the Wilcox here? Okay. All right, so Madam Interpreter, we're going to go, I'm going to do one matter and then we'll put you in a breakout room with the attorney and the client. And then let's go on the record in the matter of the City of Wyandotte versus Stephen Wilcox, 251158.
Your Honor, good morning. Richard P. Serrano, P. 33828, appearing on behalf with my client, Mr. Wilcox. Your Honor, he's presently on Zoom. He is in the Parnell Correctional Facility in Jackson, Michigan. Sir, please state your name for the record.
You need to unmute Mr. Wilcox.
Please state your name, sir.
He's not unmuted yet, Counsel. You're still not unmuted, sir. You need to unmute.
There you go, sir.
Thank you. Your name for the record, please.
Stephen Wilcox.
Okay, thank you. Today is the date scheduled for the adjourned pretrial. This matter has been adjourned a number of times, awaiting the Center for Forensic Psychiatry Criminal Responsibility Report. Did you end up receiving that, Counsel?
Yes, the prosecutor and myself have both received it. We've talked about it. And, Your Honor, I've informed my client and that he was deemed to have criminal responsibility. And with that, we'd like to go forward with the plea that we
Okay.
stated.
All right, do you have a copy of that report, Counsel? Because the court is not in receipt of that report.
Your Honor, I was not aware this was scheduled for today, so I did not bring it with me, but I do have it.
Okay, will you please email that to the court so we can put it in our file?
I certainly will.
Thank you.
Or I'll just bring in a copy, hard copy, would rather.
Whatever's easier. We just need to make sure that we get a copy of it for our records.
May we proceed with the plea, Your Honor?
You may, yes, you may.
Your Honor, after speaking to my
Well,
client.
I'm so sorry. Wait, just one moment. I just need the prosecuting attorney to stipulate then to the report.
Okay,
Do they have a copy of the report?
you're now, I don't know, I'll have to ask her.
Okay, Gordy, can you ask the prosecutor to come in and if they have a copy of the responsibility report for Mr. Wilcox, if they can bring it in, please?
how we.
Good morning, Your Honor. Yeah, excuse me, I'm P85417 for the people of Wyandotte.
All right, thank you.
I do stipulate to the findings of the report, and I do have a copy of the report that I can give to your staff.
Perfect, that'd be great, thank you. If I can see if I can see that, please.
Yes.
So the court does not need me to produce another one, Your Honor?
That's correct, counsel. This is dated March 5th, and it was received by counsel on March 11th. Somehow we don't have that. Interesting.
We were on notice that it was gonna be here March 11th, and it did finally come, so the prosecutor and I, well, both examined it. We stipulated to the entry.
All right, well, I haven't had a chance to review the entire report, obviously, but all right, so it's the examiner's opinion that Mr. Wilcox does not lack substantial capacity to appreciate the nature and quality or wrongfulness of his behavior, or to conform his behavior to the requirements of the law during the legally relevant time, cognizant of his behavior, aware of his surroundings, and even the examiner even reviewed body-worn camera. Actually, I'm quite impressed. So, and he was able to respond in an organized manner and provide reality-based responses, as well as comply with directives. So therefore, it is the examiner's opinion that Mr. Wilcox does not have an intellectual disability or a statutorily defined mental illness of the timely alleged incident offenses, and that he does not lack substantial capacity to appreciate the nature and quality or the wrongfulness of his conduct, or to conform his conduct to the requirements of the law, and that Mr. Wilcox does not meet statutory requirements for any sort of legal insanity defenses. And we need to make a copy, you said?
Yes.
Okay, we'll make a copy of that. Okay. And so okay. Okay, and so then counsel, as to the pretrial portion.
Yes, Your Honor. After pre-trying the matter a number of times and the reports and my client being advised, he wished to avail himself of the offer and that he will be responsible to the amended charge of malicious mischief, a civil infraction. He's admitting responsibility because he is aware it's the best way to resolve this matter, and that he understands the nature of the proceedings. He understands he's waiving his rights to have any subsequent trial in this matter. He's been advised of his constitutional rights. Your Honor, my client is quite intelligent and very versed in the law. I've been quite impressed with having him as a client. He's been very cooperative. In fact, Your Honor, he's coming up on a parole decision very shortly, so I wish him the best of luck with that. We hope the court would accept the responsibility plea and dismiss the criminal matters pending. Thank you.
All right, so I know you said malicious mischief, but it shows disruptive behavior.
Oh, is that what it's called? I'm sorry, Your Honor. Yes, disruptive behavior.
And when are you set for parole, sir? For parole determination?
I saw the parole board on March 12th. They gave me what's known as a deferral, so they're waiting for a current psychological evaluation. I anticipated being sometime July-ish. If they perform their usual. When you see the parole board, they don't never let you go the same day. It's usually 90 days, 120 days from when you get a decision.
And what are you in MDOC custody for, sir?
I'm back on a parole violation that arose out of this situation in Wyandotte.
Okay, sir, let me ask a different way. What were you on parole for?
Oh, larceny by conversion.
Sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes.
Knowing all that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right. Any immigration issues?
No, ma'am.
All right, the court will accept the plea as knowing and voluntary. The court's going to waive any fines and costs, as I don't know when he'll be out to do that. So, all right, you're all set, sir. Good luck to you.
Appreciate that.
Thank you, Judge.
Need to
Mr. Wilcox, good luck.
leave a copy at some point for that.
Thank you,
I'm
Mr.
gonna-
Rano.
I'll just need to vote on that.
Okay, friends, almost 1 hour in the books already. Morning is flying by, isn't it? Let's stay in Michigan. Let's go over to Judge Simpson.
I have before me a plea sheet. In this case, the defendant is going to plead no contest to the charge of failure to report an accident under 662 90-day offense. Upon a successful no contest plea, count one would be dismissed.
That's correct, Your Honor. That's correct, Your Honor.
All right, very good. Need you up at the podium, young man. Raise your right hand. Be sure.
solemnly sworn to affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
George Walker.
Sir, it is this court's understanding that you're going to plead no contest to the charge of failure to report an accident. That is a misdemeanor, punishable by up to 90 days in jail, $100 fine plus court costs. You understand that?
Yes.
You understand what a no contest plea is?
Yes, Your Honor.
All right. Two things about it I have to make sure that you understand. The first thing is that you need to understand that it means that you're not further desirous or wanting to contest this charge. You understand that? Yes?
Yes.
Okay.
Sorry.
The other thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes.
Basis for the no contest plea, Mr. Elm.
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You had previously signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
Your Honor.
Look at paragraph 5. You'll see a copy right there on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided Pittsfield Township Department of Public Safety report for their case number 25-11648. Any objections to the court having reviewed that report?
None from the people? No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you, between the time of sentencing and the time of my acceptance of your plea, if you commit misconduct as defined under the Michigan court rules, the court would not be bound by any sentence recommendation or evaluation. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people? No, Your Honor.
Have I complied with the court?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. I don't know that there'll be a necessity to send the defendant over. I would proceed to sentencing immediately if you but I understand there's an issue regarding restitution.
Yes, Your Honor, and we do have the victim here. We were prepared to do a restitution hearing if the court wanted to take your testimony on that matter.
I would. Have a seat, though.
And after that hearing, Your Honor, if you wanted to do immediate sentencing, we would have no objection.
All right, very good. Why don't we try to get it out of the way? All right.
We'll call Daniel Cope.
Sir, please come forward. Please, Laura.
You take a seat, raise your right hand. Do you solemnly swear to affirm the testimony about to give be the truth, the whole truth, and nothing but the truth, so help you God? Work class.
Daniel Pope. It's COPD.
All right.
Thank you. Good morning, sir. How are you doing? Sir, were you involved in a crash on June 13th of 2025? What vehicle were you driving? Was there any damage that that vehicle suffered as a result of that crash? I'm showing defense counsel has been pre-marked People's Proposed Exhibit 1. I believe this will be admitted via stipulation, but I don't want to. So I'd move to admit what's been pre-marked People's Proposed Exhibit 1 by stipulation.
All right.
May I approach the witness?
When?
So, sir, I'm handing you what's been admitted now. Exhibit 1, I have a copy for the court as well, the court would like. These are the photos that are in the report. Copy of them.
Yeah, okay. Got it.
Sir, this document in front of you, do you recognize these photographs? And do you recognize the vehicle in these photographs? Whose vehicle is that? All right. And so there's 3 photographs on this page, starting with the top left one. Can you describe what's in that photograph?
Sorry, Jen.
And it looks like there's some damage to that vehicle. Was any of that damage, or do you know what caused that damage? Was any of that damage on the vehicle prior to the crash? All right. Going to the top right picture, what is that?
That is the left driver's side frame. The hole you see right there is where the crossover, the left crossman was connected to that hole right there to the frame. And you see, I don't know how good this picture is to you guys, but crossman was supposed to go in that hole right there. But got snapped off.
And how about the bottom left picture? What is that?
My driver's side and left side.
Okay. Now, the condition of your vehicle in these pictures, is this the same condition that it was prior to the crash aside from the damage? Was there any work done in between the crash and when these pictures were taken, to your knowledge? In between the crash and when these photographs were taken, was there any work done on the vehicle?
Yes.
What work was done on the vehicle between?
Someone happened to crash, right?
So the crash occurred, and at some point these photographs were taken.
Yeah. No, I'm sorry.
Okay. Do you remember when these photographs were taken?
The day of the accident would be June 13th.
Okay. Did you ever seek to get the damage repaired?
After that, yeah, I'm not planning on getting it repaired after the accident occurred.
All right. What did you do in order to get the damages repaired? Who did you talk to?
Well, first I had to make a claim for my insurance company. Damage, the insurance takes a little while to do. So I had to, that's choose where I can,
What was the? Why didn't the insurance cover all the damage?
Well, I mean, I did have full coverage, and so the estimate, they gave me, I mean, based on the prices and those are like auto body shops and like that wasn't generally covered. So I guess because it's 2007, they don't want to cover the whole expenses, Your Honor.
Because they really totaled it out and let you keep the vehicle.
Yeah, good.
Yeah, that's exactly what they did. Okay, go ahead.
Okay. Sir, did you ever take this to an auto shop for repair?
Yeah, I did.
Which auto shop?
It's what?
Does the name A2 Auto Group mean anything to you?
Yeah.
And when you went to that auto shop, was it for these damages or for something else? Did they ever provide you with any estimates or invoices related to these repairs?
Yes.
And what specifically did you have them try and repair, or did you ask them to repair?
Well, the first job, this is for my safety because it's my vehicle. I need to get the crossing. I was connected to the second picture on the top, the right side. That's where the crossing is connected to. It was dangling there, but so I need to keep that put something else causing more severe damages.
I'm showing defense counsel has been marked as People's Proposed Exhibit 3. I apologize, I'm going a little bit out of order here. May I approach the witness?
May.
Sir, I'm handing you what's been marked as People's Proposed Exhibit 3. Can you please take a look at that document and let me know if you recognize it?
Yes, I do.
What is that document?
That was the first stop. I had to get down to my GMT there, the cross member job.
And this document, but what specifically is the document?
It's showing the receipts and the cash of the money that I got to pay to get it fixed.
And is this a fair and accurate copy of that invoice or receipt? Are people move to admit what's been marked as People's Proposed Exhibit number 3?
No, there.
Exhibit 3.
I have a copy for the court. The court would like that as well. May I approach?
Yes.
So, sir, looking at this document on the right-hand side near the top, there's some columns that say labor and description, and then on the left-hand side it says part and description. What is that, or what was being serviced?
So the cross member needed to be the reverse full crossover versus the piece was connected to the frame. You know, that needed to be placed because it was basically broke off, snapped off.
And then where it says total and balance due, it says total, I believe, is 1,200 and balance due is 0. What does that mean?
So that means that's pretty much hours and labor for the job.
I guess what's the difference between those two lines? Do you know?
So still in the total trauma. I don't think there is no difference, to be honest. It's just, I think the mechanic wanted to just all count itself together as one, you know what I'm saying?
Was there a problem with your cross member before this? Was there a problem with the support, their cross member before this? Accident.
When I got a year prior before the accident, it was perfectly fine. It was, you know, like I said, the truck came from a dealership saying I'm still paying for it. I mean, the truck was in mint condition. It was a nice truck, besides a little bit of rust. But it's pretty common for Michigan vehicles.
Fine. Thank you. And so, sir, how much was paid out of pocket to replace that cross member?
Well,
I'm showing defense counsel was marked as proposed exhibit number 6. May I approach the witness? Sir, I'm hearing people proposed exhibit number 6. Do you recognize this document? And what is that?
that is the main receipt we received from the bottom again.
Is that a fair and accurate copy of that receipt for that invoice?
Yes, it is.
People are moved to move to mark proposed exhibit 6 into evidence.
Any objection?
No, Your Honor.
Exhibit 6, submitted.
May I publish to the court? So, sir, who actually paid this $1,200?
Yeah, today.
All right. Other than that cross member, what other repairs did you get done?
Yeah, well, the pictures right here from the first picture is the body needed to be done, and then the driver's side cab needed to be replaced. Yeah.
Did you ever get an estimate for how much it would cost to get that done?
After calling around, that's why I came to the conclusion of H2 Auto. He was the cheapest one, and the estimate was, well, it was about $5,000.
How many different auto shops or dealerships did you speak to in order to get an estimate for these repairs?
Insurance, they two of them, they recommended for me to reach out to see how much they would charge, and they was too out of my price range. It was too expensive.
Do you remember how much the estimate was for those two that your insurance recommended?
It was the first one, and I think when I first reached out to the first one, they said it's going to take about over a month to repair the damages. You know what I'm saying? And I can't really tell you the bottom dollar how much I know it was a lot more than what we could manage.
So you got no written
witness.
No written estimates from these other places?
No.
Go ahead.
I'm showing defense counsel's marked as people's proposed exhibit 2. May I approach the witness?
Doing.
Sir, I'm handing you what's been marked as people's proposed exhibit 2. Do you recognize this document?
Yes, I do.
What is it?
This is all the breakdown of what it took to replace the cab. Sarah.
And is this is it fair to say this is an estimate for that repair? And is this a fair and accurate copy of the estimate that you got from A2 Auto Group as it relates to these damages? People move to admit what's marked as people's proposed exhibit 2 into evidence.
No, Your Honor.
Exhibit made. Thank you. That's, yeah.
So, sir, looking at this, what was the estimate from 8 Auto Group for the repair to the cab and the body?
Well, after I explained, after I told him what the insurance was going to give me to cover the difference, he told me he would probably an additional $3,000 to do the job.
What was the quote from the dealership for how much it would cost to repair your vehicle's damage for the body, not the cross member, just the body?
Right, so his quote was, 49.
Is that the 49.39.64 on page 2? Okay. And of that, how much did you say your insurance would cover?
The insurance, I believe they, 19. But 1988.
So I've shown defense counsel's Marks People's proposed exhibit 4. May I approach the witness?
You may.
So I'm handing you what's the Marks People's proposed exhibit 4. Do you recognize that document?
Yes.
What is it?
So this is actually, this is more of a better numbers, more of the facts. The insurance check was 1932 for my insurance.
But what is this document?
Yeah, sorry. This is the document showing what the insurance was gonna get, well, they was covering me for my truck.
And is this a fair and accurate copy of that letter from your insurance?
Yes.
People move to admit what's been marked as People's proposed exhibit 4 into evidence?
No objection.
No, Your Honor.
Exhibit 4 is admitted. But they paid that check to you, didn't they?
Yes, they did.
May I approach to publish the report?
Yes.
So, sir, the amount of that check that Progressive gave to you, is that the total payment amount on this document, that 1932?
Yes.
All right. And so when we take the estimate of the 49.39.64 from, that would be People's 2. How did that 1932 go towards the $4,900 estimate?
Yeah, so that's the candidate.
And so how much did you end up actually paying out of pocket for those repairs?
I think it's just a body job, and the cost was $3,000.
I'm showing defense counsel's Marked People's proposed exhibit 5. If I may approach the witness.
May.
Sir, I'm handing you People's proposed exhibit 5. Do you recognize that document?
Yes, I do.
What is it?
This is the receipt the mechanic gave me for the job, for the cab job.
And is this a fair and accurate copy of that receipt for the repairs for the body damage? People move to admit what's been marked as People's proposed exhibit 5 into evidence.
Admitted.
Permission to publish?
Yes.
So, sir, you paid, or who paid the actual $3,000 on this receipt?
Yes.
All right. So in total, that makes the total payments from your fiance how much?
With the cost member, it came to about $4,200.
All right. Other than the A2 auto group and the 2 insurance recommended mechanics, was there anyone else that you spoke to about getting these repaired?
No, but I do, can I say this? I do know this much, that the ones they recommended was more money than what I'm at from this shop. Let me out of pocket.
So how much total are you requesting in restitution?
I just want, I guess, prepare.
I'm going to pass the witness at this time.
What are you considering fair?
So my truck, as of today, Your Honor, is fine. My truck is good. You know what I'm saying? So I'm happy with that, but it's a struggle with me, my fiance. We all have our struggles, and it takes a lot out of our savings to do, fix my truck. So I mean, on behalf of her part, that's why I'm here today. I mean, if you ask my fiance, she wants the whole amount what she out of pocket back. But I'm not a greedy man, I mean, I just, that's why I come down to the conclusion.
What are you considering to be fair then, sir?
I'd be happy if I just, okay, so I missed 3 days of my job coming here, so, I mean, fair, I mean, I just say I ain't trying to get everybody, I mean, it's a struggle for everybody on it,
I understand that, but what are you considering fair? I'm trying to clarify the last answer you gave.
I think there would be at least a body job, the 3,000 for the body.
Cross-examination.
Thank you, Your Honor. Good morning, sir.
Morning.
I'm gonna remain seated here, so if there's anything you can't hear me say or don't understand, just let me know and I'll speak up and try to clarify myself, okay?
Okay.
So you testified that when you reached out to your insurance, technically they totaled your truck, correct?
They gave me the option to total it.
Okay. Versus getting it fixed?
Yeah, just the fact because I was still paying for this truck on my dealership.
Okay. And you said you have full coverage, correct?
Yes, sir.
So if you have full coverage, wouldn't that mean that your insurance would cover the rest of these repairs outside of your deductible?
In my opinion, from my experience, this is insurance being insurance.
Okay, but you have $1,000 deductible on your insurance policy?
Yes.
Did you pay that $1,000?
I think that's what that's what they took away from the check they gave already. That's minus deductible.
So basically, they totaled your truck out for $2,932.19 and subtracted your deductible from it. Is that what you're saying?
I think in a way, I think so, yeah.
Okay, so they did.
Well, you think so. That's what they did, isn't it? They gave you the option to total it,
Yeah,
which means they would take the truck and pay you money,
yeah,
but they didn't do that.
yeah, because you know, in my opinion, my truck's worth more than what they was gonna
I
drive.
understand what your opinion might be, but I'm just trying to get a clarification on what your insurance company did. Insurance company did is they gave you the option. They paid what they would pay, which was basically 2,900. Took your deductible of 1,000. You got to keep the truck and whatever that was worth, and they gave you money.
I think so, yeah, yep.
Okay, go ahead, Mr.
Thank you, Your Honor. And sir, I want to make sure this accident happened on June 13th, 2025, correct?
Yes, sir.
Okay. And did you get any estimates before you reached out to your insurance?
No,
So how do you know how they came up with the number of what your truck was worth then?
honestly, I don't know how they came up with that number.
Okay. And you were showing a couple exhibits here. One was a document you provided from Progressive, correct?
Yes.
And that document is dated June 25th, 2025.
Are we looking at people?
The Progressive of document.
Oh, yes.
Yes, June 25th, yep.
Okay. And so this accident occurred on June 13th, 2025, correct? So 10 days later, you had essentially resolved this issue with your insurance, correct? And how many vehicles do you own that you drive?
Just the one, sir.
Just the one truck? And with a broken cross member, is the vehicle drivable?
It's not safe to drive, the broken cross member.
Okay. Yet you waited, and it looks like, and I don't have the exact exhibit number, but the date of the estimate for the cross member, that's dated July 12th, correct?
Yes.
So you waited after the insurance paid you out, you waited an additional 2 to 3 weeks to have your vehicle checked out.
The vehicle was posted.
Okay, so you didn't drive for 2 or 3 weeks?
That was a cross member.
Okay. But again, it sat there after you received the insurance check, correct?
Yes, sir.
Okay. And then even later, and I just want to find the date here, I believe it is July 17th, that's when you got the quote for the body repair. Correct?
July 17th.
It's I don't know the number, that might be. The 4,900?
That's people's two.
Do you see that date on there, sir?
On the 49 page?
Yes, sir.
Oh, yeah, okay.
Okay. So July 17th is when you got that estimate, correct? Nearly a month after the accident and after insurance had paid you out on this, correct?
Yes, sir.
And you're saying you did not drive that truck that entire time?
No.
Okay, why did you wait so long?
Well, I mean, it was a job, you know, and we saved, we tried to get a house and it's a lot going on, and we just had to manage what was the insurance was gonna cover, and, you know.
And again, insurance had basically said this truck is not worth any more than the 2,900, right?
They did not say that, they did not say it's not worth that. They give the option. They insurance, but they don't want to truck.
And your insurance, similar to a medical provider, correct? They have repair shops that they choose to work with,
My insurance did, yes.
and you chose not to work with any of the shops that your insurance works with, correct?
Yes, correct, based on these receipts, these numbers on the receipts would have been a lot more than, you know, it is if I would have went to the insurance.
But if you, so you have full coverage, and if you would have chosen not to total your truck, your insurance would have covered the entire thing, correct?
But if that's one of the truck, I would have got it, like, but it is a truck.
But you did total the truck, that's why they sent you the check. That's why you didn't have to pay your deductible.
They gave me the truck, they fixed the damages based on what, you know.
But you never paid that $1,000 deductible, did you?
They added that deductible to the 1,900.
Right, so they subtracted it from essentially 2,900, so you never actually paid them, correct?
Insurance?
Correct.
I never paid insurance.
Right, so if your insurance would have covered the repairs, how that works, and correct me if I'm wrong. But you pay that $1,000 and they cover the rest, that's the point of full coverage, correct?
For the $1,000 deductible, right?
Yes, you would pay the $1,000 of either to your insurance or to the repair shop as your portion of deductible. The insurance company would pay the repair shop the rest, correct?
Yeah, so with the 1,900, yeah, like you were saying, that's with the 1,000 deductible. So it's like you said, it was like 29.
No, I think you're misunderstanding me, sir. If you had paid that deductible, your insurance company is Progressive, they would have paid A2 Auto Group or whichever auto group you had chosen to go through, correct?
They would have paid a little bit, they would have paid, you know, the 19.
But you did choose to total your car.
No, yeah, I mean, I think it actually fallen in total.
Okay.
But I'm still, you know, like I said, the truck's got a lot of life into it, you know?
Oh, I understand that.
And for record, these trucks, based on facts, they go up to 500,000 miles. And my truck's only barely at 119. The truck has got a long life ahead of it.
Okay, and it's a 2007?
Yeah, but a lot of 2007 trucks are really nice. Inexpensive.
So what was the insurance company put a value on that vehicle, right?
The insurance.
They would have paid you a certain dollar amount, but taken the truck.
Well, like, I mean, I feel like it wasn't justified for the insurance.
I'm not asking what you feel. What your insurance company said is we would give you 2,900 for the truck. That's really what they said to you.
Instead of giving me the check, right?
Well, they would have given you 2,900 taking the truck, right?
I believe so.
Okay, and so what they did, and they gave you the other option that they gave you was, okay, you're gonna keep the truck. You need to pay your deductible, we'll give you the balance. And that's where the 1,900 some odd comes from, right? So at the time of the accident, your insurance company had valued that truck at $2,900, basically $3,000, $2,900.
Yeah, to the insurance perspective, yes.
That's what they valued the truck. Okay. You don't have any further questions, do you?
No, you're all right.
Good. Any redirect?
No, Your Honor, thank you.
Thank you. You may step down.
Your Honor, people have no additional witnesses.
Any witnesses for the defense?
No, you're.
Okay.
Any argument?
Your Honor, I think the court's heard all the testimony. I believe the witness said he'd be asking for $3,000. I would ask the court order $3,000 restitution for the damage that the victim has shown through the receipts. Thank you.
Your Honor, I believe that damage should be capped at $1,000, which is the amount that this individual's out for the cost of his deductible. I find a lot of things in this case interesting. The fact that he did take the payout prior to even getting estimates to fix the work. He chose to not go through repair shops that would have been potentially fully covered by the insurance. That's the point of having insurance. I think there's almost a double dip at the apple here, where he's received the insurance payout, and now is asking my client to cover the work that, if his truck was worth it, his insurance would have covered. And so I think what he is realistically out based on the actions of my client is that $1,000 deductible that was deducted from $2,900 $32.19 amount when he was sent the check for $1932.90.
We're just gonna take a brief recess. I'll come back to a decision on it as well as sentencing.
Thank you, Dr. All rise.
Okay, we will keep an eye on that and return a little later for the final judgment. So Judge McNally is supposed to have Horderman this morning, and here's the situation. He went live about 15 minutes ago now, and he went live in the middle of a hearing, and Horderman is not in the courtroom at the moment. So I'm wondering if the docket got started without them live streaming and we missed him. So I'm going to keep an eye and see if he shows up, but it kind of feels like they might have been having some technical issues or something like that this morning and we missed part of the docket, but we shall see. So lots going on in Courtlandia. What, about 2.5 hours to go yet? So lots to see. Let's stay in Michigan though. Let's go to Judge Aquilina.
Hey, good morning, Your Honor. Alan Crawford, appearing on behalf of Ms. Adrian Wilkerson.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. And put your hand down. Counsel, could you swap places with him, please? Thank you. Sir, are you taking any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And have you had enough time to speak with your attorney?
Yes.
Have you reviewed the pre-sentence investigation report?
Yes, Your Honor.
On behalf of the people, any corrections, additions, deletions?
Your Honor, we would have a correction to the face page. I believe that Mr. Crawford is retained.
That is correct, Your Honor.
All right, I'm changing appointed to retained on the cover page, and then is it correct on the basic information sheet? We're looking. Yeah, it says appointed and making that retained. And then let me look under evaluation plan. And this would be, it says by a public defender, but it's retained counsel. That's on the 5th line on the 1st paragraph. All right.
Thank you, Your Honor. Otherwise, we do not have any other changes to the body, only to the guidelines.
Sir, do you have any changes to the body?
Your Honor, we had one change that we would like to make. Under the description of the offense narrative, it's listed as page 2, the second full paragraph from the bottom. It begins, officers spoke with witnesses at the scene. Then a few sentences over, several witnesses stated that Bonilla punched the suspect and physical altercation occurred. However, other witnesses advised the suspect was the aggressor prior to the physical altercation. Your Honor, there were witness statements in this regard. However, that is not what occurred in this matter. I think it's undisputed that my client was not the initial aggressor in this.
Okay, and so this is on page 2 under description of offense narrative.
Yes, Your Honor, the second paragraph from the bottom.
Oh, from the bottom. Okay, yeah. on behalf of the people?
Your Honor, I believe the defense counsel's statement indicates that there actually were witnesses that advised that the suspect was the aggressor prior to the physical altercation. If the court would like, we could indicate that other witnesses disagreed. That could be a compromise, but I don't believe that taking out that sentence would be accurate reflection of what the police had received from witnesses from the scene.
How about I say other witnesses and defendant disagree?
That's fine, Your Honor.
All right, changes been made.
And I have no other corrections to the factual information, Your Honor.
Thank you. As to the guidelines.
Thank you, Your Honor. As it relates to the PRVs, we would request that PRV number 5 be scored at 2 points.
Any objection?
No, Your Honor.
Would you like to state the reason?
Yes, Your Honor.
There's an appeal.
Yes, Your Honor. The defendant only has 1 scorable prior misdemeanor.
Thank you. You would agree?
Yes, Your Honor.
All right. PRV 5 is 2.
We would ask that PRV number 7 be scored at 0 points. The defendant does not have any concurrent scorable felonies.
You would agree? All right, it is 0.
That makes the total PRV score at 57 points. It does not change the level.
Thank you. Next.
As it relates to the OV scores, we would ask that OV number 6 be scored at 25 points. That is the score for the defendant's intent to kill, and that the defendant had an intent to do great bodily harm at the time that he committed the crime.
Response?
Your Honor, we'd be in agreement with that.
Thank you. OV 6 is 25.
Thank you. And then we would ask that OV number 12 be changed to 5 points. And that score is in relation to the that counts 2 contemporaneous felonious criminal acts involving other crimes that were committed, and those counts being dismissed in exchange for the plea.
That's correct, Your Honor.
OV 12 is 5.
That changes the total OV score to 145 points. It does not change the level. Range does not change.
Do you have any corrections?
No, Your Honor.
All right, let me change basic information sheet to reflect the changes. Change the basic information to reflect the 57 and the 145, and then checking the recommendations to see if they have done anything with that. Doesn't look like those are mentioned anywhere that I'm finding, so. Oh, yes. So. No, we're good on the recommendation narrative. All right. Thank you. Do we wish are there any victims who wish?
Yes, Your Honor. I understand that there are 4 victims that would like to be heard by the court.
Thank you, Counsel. You can have a seat with this one.
Thank you. We would have, there are 3 now, Your Honor. Maggie Bonilla would like to. Yes. Would you like to someone to speak with you?
Being here, please raise your right hand. Do you swear or affirm the testimony you're about to provide for the truth, whole truth, and nothing but the truth on the penalty of perjury? I do. Thank you. Put your hand down. Please state and spell your name for the record.
First name is Magdalena, Magdalena. Last name is Bonilla, Bonilla.
I appreciate you being here.
Thank
Take your time. I know you've got your phone there, so you're going to be reading something.
Yes, I am.
If you need a break, let me know. Take your time, pretend you're reading to a 5-year-old so that we all get it all. It's important. Sometimes when people read and they're nervous, they read really fast and it's difficult for the court reporter. So I have a court reporter here who will get it, but I want to make sure it's right. Okay?
Okay,
You may proceed.
Your Honor, my name is Magdalena Bonilla. I am the wife of Christopher Bonilla. I am here because his life was taken from us. My husband and I shared decades together. He came into my life when my daughter was just 2 years old and raised her as his own. Today, she is 32 years old and is the only father she ever knew. This case is not just a charge or a file number. A human life was lost. Someone who was deeply loved, relied upon, and irreplaceable. Our family will live with that loss for the rest of our lives. Since my husband's death, nothing has returned to normal. Ordinary days are no longer ordinary. Holidays, milestones, and even quiet moments are marked by his absence. Grief is constant and has permanently changed the course of our lives. The emotional impact has been severe and lasting. We live with trauma, pain, and the knowledge that his death was preventable. That reality weighs on us every single day. The financial impact also has been significant, creating instability and hardship directly tied to the offense. This loss did not just affect one person. It impacted an entire family across generations. My children lost their father. My grandchildren lost their grandfather. Our foundation as a family was shaken in a way no one can repair. Today, this court must impose a sentence, and I'm asking for firm accountability. This offense did not occur in isolation. The defendant's criminal history reflects a repeated disregard for the law and for the safety of others. Prior involvement with the justice system did not prevent this outcome. That pattern ultimately ended with the loss of a human life. Michigan sentencing principles require consideration of punishment, deterrence, and the protection of the public. When repeated criminal behavior escalates to fatal consequences, the sentence must reflect the seriousness of that harm and the need to prevent further danger to the community. Nothing this court does today will bring my husband back, but the sentence imposed today will speak for him in a way he no longer can. I am asking this court to make sure that his voice is clearly heard. Thank you for allowing me to speak on.
Man, you clearly spoke for him. He's standing with you. I know he's proud of you.
Thank you.
I also know that he is still with you, just in a different form. But you still hear him. And I'm so very sorry for your loss, but your strength is clear.
Thank you.
And as a family, I know you're gonna come through this. I also know it's going to affect you every single day, that trauma and pain isn't gonna go away. I've heard what you have to say.
Thank you.
And you should still be here.
You should.
But you're honoring him, and I thank you for your strength and being the voice, not just for him, but we have far too many victims. I have far too many families broken by gunshot. Thank you.
Thank you. I appreciate you.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth?
Yes, Your Honor.
Under penalty of perjury.
Yes, Your Honor.
Thank you. You put your hand up. Please state, spell your name for the record.
My name is Maricela Bonilla, Maricella
All right. And what would you like me to know?
Okay. Hello. Thank you, Your Honor, for allowing me to speak today. My name is Maricela Bonilla, and I am the daughter of Christopher Bonilla. I am not here today only to speak in grief. I am here today to speak in truth. And the truth is, my father was not anyone's to take. The truth about Christopher is that he was a kind man. If you have crossed his path in everyday life, he would have treated you with respect. In a world that was often turned its back on people, my dad showed compassion. The truth about me is that when I heard the news, I didn't cry at first. I listened for him. I made a promise that I would fight for him, that I would show up no matter how hard it was. I promised that I would never let him feel alone. My family and I were always his strength. We were the ones who stood beside him when life became heavy. This crime did not just take my dad's life, it changed every part of mine. There's not a day that goes by where I do not feel his absence, in the quiet moments, in the milestones he will never get to see. In the phone calls I can no longer make. I carry grief, anger, and heartbreak all at once. But more than anything, I carry the love I had for my dad and the pain of losing him in a way that should never have happened. The person Christopher was, his kindness, his presence, his role in our family can never be replaced. Thank you, Your Honor. I ask that you consider the depth of the harm caused, not only to my dad, but to everyone who loved him and depended on him. Christopher Bonilla mattered, his life mattered, and the impact of his loss will stay with us forever. Thank you for allowing me to speak today.
Well, you've honored your father, and I promise you, and I can't promise much, but I promise you he walks with you every day, and he is part of all of those things you want him to be part of. So just know that he's with you, you've honored him, you are his voice, and at some point you'll be reunited, but I agree with you, you should not have been taken. I've heard what you have to say, and I appreciate your strength, the strength that you all share, and that he was part of giving you. You've honored that.
Thank you.
Good morning, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. You may put your hand down. Please state and spell your name for the record.
Kristen Bonilla, Kristinbonilla.
Thank you. What would you like me to know?
Your Honor, my name is Kristen Bonilla, and I am here to speak on behalf of my family and myself about the loss of my father, who was shot and killed in February of last year. My dad was not just another person whose life was taken. He was our everything. He was a dad, a friend, a brother, a cousin, an uncle, a son, a husband, and most importantly, a grandfather. That title grandfather was something he was truly the best at. It brought out a side of him that not everyone got to see. To his grandchildren, he was gentle, playful, patient, and full of unconditional love. He adored them, and they adored him right back. To someone who didn't know him, my dad might have looked intimidating at first glance, but he was a gentle teddy bear. He had the biggest heart. He was the kind of man who would be there for anyone, even a stranger. There was a saying that he'll give you the shirt off his back, and that was generally who my dad was. He was giving, selfless, and always willing to help, no matter the cost to himself. My father was funny, honest, and a hard worker. He took pride in providing for his family and protecting the people he loved. But more than anything else, he was loyal. Loyal to his family, loyal to his friends, and loyal to the people he cared about. He loved his kids deeply and unconditionally. He never questioned whether we were loved. We never questioned whether we were loved. We felt it every single day through his actions. Since his death, the impact on our family has been devastating. He was our provider and our protector. He was the glue that held our family together. Before this happened, we were incredibly close. So tight that it felt like nothing and no one could ever tear us apart. But losing him did. Without my dad, everything has fallen apart, and we are left trying to survive in a world that feels completely different without him in it. The pain of his absence is constant. Holidays, birthdays, and everyday moments are now filled with a void that can never be replaced. His grandchildren will grow up missing the grandfather who loved them so fiercely. His children are left navigating life without the man who was always there to guide, protect, and support. This loss is permanent. Our family will carry this grief for the rest of our lives, and the love he gave us will stay with us forever. Thank you for allowing me to speak for my father.
Thank you. Well, you honored him, but let me just tell you, I know he's not here, but he still is your protector. He's your guardian angel. As I said earlier, he's walking with all of you. And I do know, I know you say you're all broken, things are different, but you're going to emerge stronger and more together. And you will all keep him alive for the grandchildren by sharing all those wonderful times and memories and history, because that's important to them. It's also important to you. And every time you share a story, you know he's with you. And at some point, although now you may cry while you're telling the story, you'll find joy and peace in his memory and sharing all that greatness that he brought into your life and into our community. And I'm so very sorry for the loss you all have suffered and our community has suffered. We need good people. We need them to be here and not be taken down by gunfire.
Exactly.
So he left you all with big hearts and love, and he is still sharing that with you. And thank you so much for being here.
Thank you so much, Hannah.
Counsel, is there restitution that is being sought?
Your Honor, thankfully, the family did make an application to the Crime Victims Compensation Fund, and they were given $8,000. We'll be requesting restitution to the Crime Victims Compensation Fund in the amount of $8,000.
And that is for funeral and related expenses, is that right?
Yes, that's correct, Your Honor.
All right, thank you. On behalf of the people, what would you like me to know?
Yes, Your Honor. The defendant has a long history. It's a long violent history, as Your Honor has seen in the PSI. What I find very telling about this situation is on page 8, under defendant's description of offense, the defendant declined to provide a statement. Those are the words of a person who fancies himself as a victim of his circumstances. The defendant filed a sentencing memorandum in this case that did nothing but sully the character of the victim in this matter. But let's talk about the defendant. The defendant made a choice on February 16th, 2025, when he left his house with a gun he was not supposed to have because he was a felon, put that gun in his waistband, walked into a strip club, and decided to drink the night away. What good is going to happen or come of drinking the night away when a felon has a gun tucked away in his waistband? As everyone knows, emotions get high. You may see someone that you may have a beef with, and that's exactly what happened. And what he did was bring a gun to a fist fight. Instead of walking away, instead of learning what he learned in prison when he did his prison term for witness intimidation on a case he wasn't even involved in, for a murder where he beat up a witness from a first-degree murder case that he had nothing to do with. He pulled the gun out in a fist fight, and he shot Christopher Bonilla in the stomach. And instead of standing there and providing any type of assistance or calling the police or doing anything that he could, like an actual victim would have done, he picked up his gun that shot what seems to be rifle rounds, and he walked calmly out of the building, stuffing the pistol back into his waistband, got into a car and left the scene. And where, by chance, is that gun? Where has that gun ever gone? It's never been found. He never called the police. He never did anything to help the situation. That is not how a victim acts. Yet this person who wants to fancy himself as a victim and sully the reputation of Christopher Bonilla in a sentencing memorandum doesn't want to make a statement on his own behalf. Very telling, Your Honor. We have a family that has lost their patriarch. Their cornerstone of their family. And all because of what? Because of a decision that Adrian Wilkerson, Dirty is what his name is, that's how everybody knows him, Dirty, made a decision that day. He made a decision to put a pistol in his waistband when he wasn't allowed to. Things any grown adult should know better than to do than to walk into a strip club with a pistol in your waistband. So I would ask that Your Honor take those statements from the victim's family into account when you're forming your sentence in this case. Because though this is a plea to a manslaughter and a felony firearm, I think those are huge issues that we have here. And I think that the defendant has to understand that that's not how normal people operate in our community. And I would ask that Your Honor follow the guidelines and sentence the defendant to 144 months to 360 months on count 7 and consecutive to the 24 months in count 6. Thank you.
Counsel, there was no sentencing agreement, was there?
That's correct, Your Honor.
Counsel?
Would you like me to address the court from here or from?
No, from the podium, please.
Your Honor, there's no denying that we're faced with a difficult decision in here in this matter and a difficult set of circumstances. We have a family that lost a loved one that they'll never be able to get back. And my client is going to be spending a significant amount of time in prison as a result of his actions. Now, the probation department and the prosecution has made a recommendation for 144 months in this matter for the manslaughter charge. We respectfully disagree with that recommendation, as we do feel that that ignores the facts of the case and the history and characteristics of my client as well, Your Honor. Now, I did file a sentencing memorandum and detailed a lot of what occurred in this matter, and I think that it's undisputed as to what happened during this incident, Your Honor. My client is at a bar or a nightclub, and while there, he's sucker punched. And then he's attacked by multiple people from multiple angles. There was no one coming to his defense. Security at the club was not coming to break this fight up. And yes, my client is a felon, and he was wrong, and he had a firearm. It was illegal for him to do that. And in the midst of this attack, he shot and killed Christopher Bonilla, Your Honor. It's on video. We can't run from those facts. We can't hide from it. That is what happened on this night. But I think it's important because when my client left from home, he never in his mind envisioned what was going to be happening this night. He never thought that he'd be using his firearm. He never thought that he would be attacked and sucker punched in the club. And he didn't know that there was someone who was holding a vendetta against him. Your Honor, for the last several years, my client has been living his life the right way. He removed himself from negative influences and the street lifestyle. Mr. Wilkerson he successfully did what we want all prior offenders to do. He reformed.
How did he reform, counsel, when he violated the law where he couldn't have a weapon? Let's start from there. I understand what you're doing and it is your job and you're doing it very well, but let's be very clear. His reformation included violating the law by carrying a weapon into a bar.
And for that, Your Honor, he is wrong. He had a firearm. He wasn't supposed to have one. But when we focus on the other aspects of his life, this is someone who had no education, who took it upon himself to go out and earn a general education degree. This is someone who had no skills or training, took it upon himself to earn a commercial driver's license. He was working, he was doing everything the right way. And in fact, my client had confided in me that he hadn't been out to a nightclub since he was released from prison. This was the first night that he had went out. All that he did was focused on his family and his work. He worked 2 jobs around the clock, driving a truck up and down the state of Michigan and throughout the various parts of the country. He worked on the weekends here at another job in the Lansing community. He was doing everything that he could, and his family was proud of him because he did a complete 180 with his life, Your Honor. And I feel for that, he should be getting some credit. Yes, we have a serious case in this matter. An individual lost their life, but I don't think that we should completely ignore everything that my client did to reform.
Sorry about that.
It's okay. I don't think we should ignore everything that my client did to reform and rehabilitate himself. He made a mistake, and I don't think that he's worth us just giving up on, Your Honor. Now, the prosecution had made some arguments about my client declining to provide a statement to the probation department. My client has an absolute right to remain silent, and he declined to make a statement to the probation department on the advice of counsel. He should not be penalized for that. He came into court and he made a factual basis about what occurred that night, Your Honor. I think in light of all the circumstances and everything that did occur on this night, my client's history and characteristics, as well as the history and characteristics of the victim in this matter, Your Honor, we would be asking the court for a sentence of 60 months for the manslaughter.
Sir, let me just remind you, you pled to count 1 homicide manslaughter with the habitual third. It is punishable by up to 30 years, and count 2 weapons, felony, firearms is 2 years preceding the sentence that I will give you on count 1. And counsel, I respect what you had to say, and you have a job to do. However, he pled guilty. It wasn't no contest. He doesn't have a right to remain silent, but once he has pled, I'm unclear how being accountable is something that he chooses to do. Sir, do you wish to make a statement or not?
Yes.
What would you like us to know?
I would like to begin by expressing how truly sorry I am for what happened last February. I know that looking at my criminal history is easy to make an assumption of who I am. And Your Honor, I'm disappointed in myself. I'm back in a position I promised myself and my mother that I would never be in again. My last criminal offense was over 10 years ago. I changed everything about who I am and who I was. I earned my GED, I earned a CDL, and was going through therapy, self-admitted. For once, everything in my life was going great. Then in February of last year, I went out with the intentions to just unwind, but I never envisioned that I would be attacked. I'm so far removed from that life that the thought of being sucker punched and then being jumped just wasn't even in the realm of reality for me. I regret that a life was lost, and for that I am sorry. I'm not proud of this. This is something I have to live with, something I've been living with, something I am one day going to have to answer to God for. Regardless of how this incident unfolded, who was drunk, and who was the aggressor, I am sorry for the role I played in it. And I pray that the family can one day find it in their hearts to forgive me. And I ask that the court takes everything from this case into consideration. I'm asking for leniency, mercy. Thank you.
I have no leniency and no mercy to give you, because what I see is an escalation. What I see is someone who has said, I've done all of these great things, and so I want you to give me credit for violating the law, carrying a gun into a bar and firing twice into a human who dies. Could have fired into the ceiling. That would have scared everybody. That would have been a cry for help, if that's what you needed. But taking a gun to a fist fight doesn't work. You were a felon, you knew you couldn't have a weapon. You chose to drink. You had control of your life, how much you drank, and whether or not you took an unlawful gun with you. So all of these great things that you did and that everybody's so proud of gets erased by carrying a weapon concealed unlawfully on your person in a bar where you drink. So your decision-making is clouded by the alcohol. But it was already clouded having no alcohol when you put that unlawful weapon into your waistband without the proper license or authority, and then you use it on a human being, a valuable human being. Now, maybe you didn't give a crap about him, but the community does, and his family certainly does. They will be forever without him. He will not share birthdays, holidays, graduations. There are no more hugs. There are no more celebrations with him. His family has to keep him alive by the memories he left behind, by the footprint he left behind. Your sorry doesn't cut it for me. You do not just have 1 or 2 crimes. You have what, 7 felonies? And what, another 6 or 7, let's see, 6 felonies prior, now it's 7, and 5 prior misdemeanor. What haven't you learned those other 13 times you were before a judge? If anybody speaks out anymore, the officer will take you into custody. It is contempt. 93 days jail and or $7,500 is contempt. I don't care about the money, but you'll have 93 days in our hotel in Mason. So I expect a quiet courtroom. I don't know where your counseling went wrong. I don't know where all these good deeds went wrong, but they didn't go far enough. You need some significant time behind bars so that when you are out, the rest of us can be assured that maybe you learned your lesson and you can keep us all safe. There's a man who will not be able to have conversations with his family. You'll be behind bars, but you can still see your family and they can send you pictures and they can come visit you. Unlike the man who was loved that you took down. As to count 1, homicide, manslaughter, you are sentenced to 171 months to 360 months. 0 credit days. You will pay private assessment in the amount of $130 and a $68 state cost. As to count 2, weapons, felony, firearms, you will serve 24 months with credit for 402 days that you've already served. That time will be served consecutive with and preceding count 1, which technically is count 6. And count 7. I think we need to change that on the cover page. You will pay a $68 state cost. You'll also pay $8,000 in restitution to the Crime Victims Fund to repay that for the restitution they paid to the family of the victim. The restitution will be paid first, and the crime victims assessment and the state costs will be held in abeyance until he's released. I want the restitution paid first. While you are incarcerated, you will participate in cognitive behavioral trade school. Anything else you would like him to participate in?
No, Your Honor.
All right, I'm sure the Department of Corrections will have other programming for you, sir. I believe that this punishment, given the circumstances, the escalation, and the thoughtlessness that went into bringing a gun, an illegal gun, into a bar, being drunk and firing it against a punch or two or three. I believe this punishment is sufficient and proportional. It speaks to the necessary continued rehabilitation of defendant. Hopefully it deters others and protects society. There are far too many illegal weapons and people who decide they want to be all powerful and excuse their actions away by carrying a gun. You have 42 days to appeal and to request appellate counsel. Please give him his appellate rights. The form should be right in front of you, sir. Is there anything else that we have for people?
No, thank you.
No, Your Honor.
Thank you. Sir, that's the form you use if you would like to appeal. Additionally, I should say there'll be no contact with the family of the victim. You understand that, sir?
Yes, Your Honor.
You acknowledge receiving your appellate rights?
Yes, Your Honor. It's actually the
You may give them to the clerk. Thank you. That is all for this record. Thank you.
Alrighty, friends. We're going to go over to Judge McNally, but an update there. My suspicion that they might have had tech issues this morning, I think, is correct. Thank you to Austin, who in our private chat informed us that he looked it up, and this morning Horderman had a unfortunate run-in with Judge McNally that ended with him being ordered to report to jail on May 5th. We don't know yet, anyways, how long he was sentenced to jail. The fact that it was pushed out to May 5th implies to me that it was probably at least 30 days, but I can't state that as a fact, and we'll try to get more information. But he's got a review on May 6th, which he'll be in custody during, and then a prosecutor review on 7/1. Those are the things we know. So the morning went bad for Horderman from the looks of things, but we'll keep you updated. But with that having been said, let's go to Judge McNally and we'll see what else he's got going on.
You got to talk to me if you don't have the money.
That's what I know.
Can you pay 40 per week?
Can you do anything lower than that?
How much?
Can I do like 80 per month?
How about 20 per week? Can you do that?
Okay, yeah, I can do that.
You do 20 per week and I'll start this on April the 10th. Okay?
Okay.
Now, if you don't have the money, you're gonna call the court, we'll go on Zoom, or you can come in here on or before the due date, 8:30 in the morning. I'll be glad to give you an extension.
Okay,
Please don't do that again, okay?
I'm not gonna do this again.
Good luck.
Thank you, Judge.
Thank you.
Thank you very much, Your Honor.
Howard Irvin, Washington Woods. 26705-742. Who's this with?
Flowers coming in.
Okay. All right, Detective, your name, please?
Oh, I was muted. Detective Chad Jacoda with Flat Rock Police Department, sir.
Good morning. I'm gonna need you to start your video though, okay?
Yes. Yes, sir.
There you go. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do.
So I have a super drunk, OWI, suspend second, and CCW. You can go ahead and proceed.
On 9/12/25 at approximately 11:38 p.m., Officer Goldsmith was on patrol in full uniform in a fully marked scout car in the area of Telegraph Road and Leonard Street in the city of Flat Rock when he observed a dark-colored four-door sedan traveling northbound on Telegraph at what appeared to be above the posted speed limit. Officer Goldsmith activated his vehicle rear radar antenna, which indicated the sedan was traveling 63 miles an hour in a 40-mile-an-hour zone. Officer Goldsmith conducted a traffic stop of the vehicle on Telegraph Road near Vreeland Road in the Taco Bell parking lot. Officer Goldsmith made contact with the driver, suspect Howard Irving Washington Woods, who was identified by his Michigan driver's license. Officer Goldsmith immediately smelled the odor of intoxicants emitting from the vehicle and Mr. Woods. Officer Goldsmith observed Mr. Woods' eyes to be bloodshot and watery, and Woods had slurred speech while talking with Officer Goldsmith. Officer Goldsmith asked Woods if he had been drinking, to which Woods replied yes. Officer Goldsmith asked Woods to step out of the vehicle. Officer Goldsmith asked Woods if he would take standard field sobriety tests, and Woods agreed. Officer Goldsmith then offered the following standard field sobriety tests: the horizontal gaze nystagmus test. Officer Goldsmith asked Woods if he was suffering from any medical condition that would keep him from participating in the test. Woods stated he did not. Officer Goldsmith explained the horizontal gaze nystagmus exercise thoroughly to Woods, and Woods stated he understood the directions. Officer Goldsmith held the stimulus, a black ink pen, in front of Woods' face, approximately 12 inches from Woods' sight, with clear view of Woods' eyes. Officer Goldsmith observes Woods having difficulty focusing on the stimulus. Officer Goldsmith instructed Woods to follow the stimulus with his eyes only. Officer Goldsmith observed a lack of smooth pursuit as the stimulus moved side to side. Officer Goldsmith observed nystagmus in both eyes at maximum deviation and prior to 45 degrees. Officer Goldsmith asked Woods if he had anything wrong with his legs that would prohibit him from performing the walk and turn test. Woods stated he did not have anything wrong with his legs. Goldsmith gave Woods instructions for the test and demonstrated the test to Woods. Officer Goldsmith observed Woods unable to hold the starting position, not walk heel to toe, never turn and walk back, step offline, and then just stop the test without completing it. Officer Goldsmith again asked Woods if there were any issues with his legs that would prohibit him from performing the one-leg stand test, to which Woods said no. Officer Goldsmith explained to Woods the test. Officer Goldsmith observed Woods miscount and put his foot down on the ground for balancing while completing the test. Officer Goldsmith then read Woods his PBT rights, to which Woods stated he understood. Woods completed the PBT test with a result of .174 BAC. Officer Goldsmith advised Woods that he was under arrest for OWI. Woods was handcuffed and placed in the rear of Officer Goldsmith's patrol vehicle. Officer Goldsmith made contact with the vehicle passenger, Justice Wade. Wade was queried through Lean SOS, and it was discovered that Wade had a warrant for her arrest out of Flat Rock PD. Wade was handcuffed and placed in the rear of Officer Hunter's patrol vehicle. Officer Hunter conducted the inventory search of the vehicle to complete the impound. While conducting the search, a 9mm pistol was located in the center console of the vehicle. The pistol was fully loaded, including one round in the chamber. Officer Hunter then secured the weapon in his patrol vehicle. Officer Goldsmith spoke with Woods and read him his Miranda rights verbatim. Woods advised that he would speak with Officer Goldsmith. Woods advised the pistol belonged to his child's mother, Tatiana. When asked, Woods said he did not have a concealed pistol license and that he knew the pistol was in the center console of the vehicle. Woods added that he was just on a date with Ms. Wade and she did not know the pistol was in the vehicle. Officer Goldsmith then spoke with Ms. Wade. Officer Goldsmith read Wade her Miranda rights verbatim. Wade agreed to speak with Officer Goldsmith. Wade told Officer Goldsmith that Woods told her earlier in the night that he carries a pistol for protection. Wade said that she knew the pistol was in the vehicle because she had seen it in the center console when Woods picked her up for their date. Officer Goldsmith transported Woods to the Flat Rock Police Department booking room. Officer Goldsmith read Woods his chemical test rights verbatim from the DI 177 form. Woods agreed to a blood test. Officer Goldsmith transported Woods to Corwell Health Trenton Hospital. 2 vials of blood were drawn by hospital lab tech William Fort. The blood was sealed in an MSP blood evidence kit, and Woods was conveyed back to Flat Rock PD for booking. The blood evidence kit was submitted to the MSP crime lab for analysis, and Woods was subsequently released pending lab results when he was sober. On 9/25 of 25, Lieutenant Rembez received the lab results from the MSP crime lab. The results were 0.172 grams of alcohol per 100 milliliters of blood. On 1/7 of 26, Lieutenant Rembez received a second response from the MSP crime lab where quantified detected substances were also found in the blood. Number 11, hydroxy delta 9 THC, 5.7 nanograms per milliliter. Delta 9 THC, 10 nanograms per milliliter. Delta 9 carboxy THC, 56 nanograms per milliliter. According to the Secretary of State, current driving status for Mr. Woods for his certified driving record 42C, his driver's license was suspended on June 21st of 2025, and he has a previous conviction for driving with a suspended license on October 6th, 2021 in Grosse Pointe Shores. It should also be noted that Sergeant Slarb queried the firearm recovered on 9/13 of 2025 through SOS, which came back with no registered owner on record.
Based on your sworn testimony, I find that the crimes of CCW, drive while suspended, revoked, denied, operating with a high BAC and operating while intoxicated were committed. There's probable cause to believe the crimes were committed by the defendant. You signed the complaint. I'm dated next to your name. I've signed and dated the complaint in the warrant. Have a great day. Thank you.
Your Honor, you too.
Sergio Ramirez.
Well, the next contestant comes up. Thank you, Ashley, for your 5 gifted memberships. I very much appreciate that, and I appreciate you.
You never speak full name. Sergio Jose Ramirez.
All right, so this is going to be a plea as charged, correct?
Correct.
So he stands mute, waives formal reading for purposes of arraignment, correct?
Yes.
And now he's going to plead his charge, right? Sir, if you plead the drive while license not valid or improper license, the possible penalties are up to 500 fines, 90 days jail, costs, or all those. Do you understand that? And did you sign, read, and understand? Excuse me. The advice or rights form.
Yeah, it's a paper, the advice of right. Yes, I have.
Did you read it?
Yes, I
Did you understand it?
Yes, sir.
If you plead guilty, you're going to be giving up all of those rights, and we're not going to have a trial of any kind. Do you understand that? All right. And do you understand? And I don't want you to tell me there could be immigration consequences
He's a
to
US
this
citizen.
plea. Pardon?
He's a U.S. citizen.
Fine. All right, good enough. You still wish to plead guilty
Yes, sir.
to the charge drive while license not valid. How do you plead? Were you operating a motor vehicle on February 10 of 23 on Sibley near Dixon, Brownstown at 1:26 in the morning? Did you have a valid license? Are you on probation or parole? Anybody forced you to plead guilty or promised you anything to induce you to plead guilty? You still wish to plead guilty? Please accept it to that charge. I'm ready for sentence. Anything?
Yeah, just that Mr. Ramirez understands that he's got to get this situation corrected so that he can have valid license. He's currently trying to take care of all of other outstanding issues in the other jurisdictions. Again, he can clear his record and hopefully start the process to reinstate his driving privilege.
Just gotta go take care of the proof of insurance to begin with. Out of Detroit. All right, anything you'd like to say as it's, anything?
The practice of getting the insurance on the vehicle now and all that, but other than that, I'm not worried about getting my license.
100 fines, 200 costs, 75 victims' rights fee, $50 justice assessment, 4.25 90 days. You have a bond of 3,010%. That's in a third party's name. Is Gilberto Ledesma here? Is he gonna let you apply the bond?
Are you gonna sign that over to him?
Is that the Brownstown one?
Yes.
Yeah.
So that's 270. Do you have the other 155 to pay?
Let me look in the file.
You've had 3 years to save your money.
Maybe that's it.
He's paying 270. How much do you have with you?
I have 20 books around. 25 books.
Pay 295 now, 40 per week, and I'm gonna start that beginning April the 6th. Can you do that? If you need more time, you call the court. And I'll be happy to give you an extension, but you have to do it on or before the due date. We're not open on the 3rd. Do you understand that? Go down the hall, you can pay the 25, he can sign over the bond and make your payments on time. Again, no reason to be afraid. If you don't have the money, call the court. We'll go on Zoom. I'll give you an extension. Good luck. People against.
All right, friends, let's go back to Judge Simpson. It looks like he's getting ready to conclude the case we were looking at earlier.
All right, we'll take care of those afterward. Good luck.
You may be seated. Chair. All right, we'll go back on the record in the case of the People versus Walker.
Morning again, Your Honor. Raymond Cook for the people.
And good morning again, Your Honor. Robert Ellman with it on behalf of Mr. Walker, who's approaching. Mr. Walker, can you please state your name for the record? George Walker.
All right, I'll make a determination on the restitution during sentencing. Is there anything that you wish to say before I do impose sentence on this case?
Your Honor, just that Mr. Walker is a young man who made a mistake here. He's here taking accountability for his actions and wishes to move forward from this in the most positive way that he can.
Anything you want to say, sir?
Yes, Your Honor. I am just like my public defender said, I am a good young man, and if I felt liable for these charges, I would have paid them all without question.
Just talking about.
Yeah, other than that, I'm just grateful to have you as my thank you.
All right, in this case, to send to the court, I'll order fines and costs in the amount of $350. I will also spend 90 days in jail with reference to the restitution. And it sometimes can get complicated with automobile crashes. Certain limitation when somebody doesn't have insurance as to what they can collect, or if they had PLPD, what they can collect. In this case, it even gets more complicated in a sense, because, and I'm going to give a couple scenarios in terms of assessing the damage. First of all, the individual will be entitled to the restitution for their loss. They are to be made whole. That doesn't mean that they can get a new vehicle. And so those would be sort of the extremes in terms of looking at it. In this case, what the victim chose to do is causes maybe for them a certain problem with the restitution. The only value I know for this vehicle is what Progressive valued the vehicle. That is $2,932.19 is what they valued that vehicle. Now, it may have had a greater value, and I'll explain that, but that's the only value that's before that I have. He could have chosen, and the insurance company gave him an option. He could have taken the $29,32.19 the insurance company would have taken as scrap, in essence, the truck. And then theoretically, everybody's done, in theory. But had he done that and then shown that the vehicle was actually worth more, but the insurance company wasn't going to pay him more, he might have been entitled to restitution for what that actual value was. But I don't have that before me. What he elected to do instead was, and he was very honest, and I appreciated his testimony, what he elected to do instead was, I won't take the payout. I will, in essence, keep my vehicle, pay my deductible, and get the back balance or get the excess amount. So if you follow the math here and the calculation here, what really ends up happening is he's paying $1,000 for that truck is really what's happening. And so he's whole in that regard in a lot of ways, because if he had done it the other way, what would have happened is he would have taken the 2,900, I'll just call 3,000. He would have taken the 3,000. They would have taken the truck. He would have said the truck is worth more, and then he would have come after him for what that amount was. That's how he would have been made whole. But he's been made whole because he has the vehicle. But that doesn't mean he again gets to take that vehicle back to what he says the condition was. Because in theory, that's not part of his loss, I don't think. And so he made a decision. Now, why would somebody make that decision? I understand why he made the decision, and again, why I appreciate his testimony. He made that decision because had he taken the 3,000, he would have gotten the 3,000, they would have taken the truck, and he would have actually never seen the 3,000. Why would he have never seen the 3,000? Because there's a lien holder. They would have paid it over to the lien holder, and he'd still have to pay on this truck that he no longer has. I get why he made the decision that he made, but that doesn't mean that he has a loss that this defendant is responsible for. He made his financial decision, and he has his truck, which he says has that value of going up to 500,000 miles. Again, most people know I'm a Ford guy. That's a Chevy. Yeah, I don't know. But anyway, I say that facetiously. But I'm just saying there is no loss. The $1,000, he paid $1,000 for the truck is what he did. Bottom line. And then he got the extra money. He could put that toward repairs. He could have put that toward anything he wanted. So for those reasons, and based upon what's before the court, I am not going to order restitution of it. When can you pay the fines and costs of $350?
Your Honor, can we have a couple of weeks, please?
Pay it by April 15th.
Gotcha.
Thank you.
Thank you very much, Your Honor.
Thank you.
Appreciate you.
Okay, now we know how that
Are
ends.
we
Let's
ready?
let's go back to Ohio, back to Judge O'Donnell.
You could go. Prosecutors in.
The old violations, which was a positive test for marijuana and meth on January 30th of 25. You understand that?
Yes, sir.
And a possession of fake urine December 26th of 24. You understand that?
Yes, sir.
And positive for meth February 27th. Oh, that's a new one. Are those the old ones, the two old ones? There are only two?
So you had, Defendant failure to reports in December 20th to 24.
You understand that charge?
Yes, sir.
And what else?
You have the Rule 11 violation, no proof of the intensive outpatient.
You understand that charge?
No, you said
I don't know. I'm losing track of you. You got so many of these things. So go ahead, Derek.
I completed that.
First, the Rule 10 violation, that's when he was in the possession of the fake urine in jail. And it was very similar, January 5th, 25. Rule 10, that's when he had an adulterated or a
All right.
urine sample.
Let's do it this way. You got the January 30th of 25. You got a fake urine charge. You understand that?
Yes, sir.
Same day you got a positive for meth. You understand that?
Yes, sir.
And possession of fake urine December 26th of 24. You understand that?
That was only one time.
All right. Well, I got you. It doesn't really matter at this point. I mean,
but I completed IOP. That's why
I think actually, Your Honor, when we were here in January of this year, that issue of the program came up.
all right.
And the
Okay, so
court,
forget about that one. Let's deal with this January 30th.
okay,
Positive test and fake urine. You understand those charges?
yes, sir.
All right, is he gonna waive the final hearing on that?
yes, Your Honor.
All right, so the old violation, what's your plea to the violation? January 30th, 25.
Guilty.
All right, I'll accept your guilty plea. Now, you got new charges. This is February 27 of this year, right, Derek?
Yes, Your Honor.
Positive test for meth, you understand that charge?
Yes, sir.
Positive test for marijuana, January 23, February 5, February 19, February 27, you understand that charge?
Yes, sir.
All right, Mr. LeConte, as to the new violations, what's he want to do?
Your Honor, we'd like to go forward today and finish this out.
So do you want to waive your right to a hearing on these new charges?
Yes.
Is that what you want to do?
Yeah.
All right, what's your plea to those new charges then?
No contact, because on the meth, I really,
All right.
I want to.
You want to have a hearing?
That would keep
On
me-
the
that would keep me
meth
free.
charges, on the new meth charges?
Keep me free.
I've explained to him the whole honey bag thing. The problem is if there was meth in it, you just meth. What to do with how in the world you ended up taking that, which I've already explained to him.
I get a chance to explain?
Yeah.
Yeah.
Okay.
So,
I don't know, would it be like last time, like, or I'm a,
I think the issue is he does not have a problem pleading guilty to the positive meth test.
Right.
He wants to explain how that happened.
That's fine. I mean, the charge is you tested positive.
Okay.
Okay.
yes,
So do you want to,
yeah,
you can either have a hearing or plead guilty to it, whatever you
I
want to do.
plead guilty.
All right, I'll accept your guilty plea and find you guilty. Now, we got all these PVs. I had let you out when you were here last time, January 7.
Yeah.
I let you out on an OR bond. And then there are several positive tests. So what do you want to tell me?
No, Your Honor, like, when I was out on the warrant for that whole year, I was smoking marijuana that whole year I was out with that warrant. And when I got arrested, like, this new weed, like, it takes longer than 30 days to get out of my system. So those dates was coming back, they was still for the previous month. You know what I mean? Like, I was only out for 30 days. I got out January 7th, the 23rd. I'm still dirty from, you know what I mean, when I was smoking before.
Okay.
I got out, man. I kept everything clean, man. I kept everything clean around there. I saw my daughter's grave, man. I keep it real with you. I don't come in here and lie. I don't play with law enforcement intelligence. I don't play with y'all intelligence, man. This is what y'all do for y'all career, man. I don't play with y'all intelligence, man. All I can do is just tell you my facts, man. I got out. I went back to my job. I got out January 7th. I was
Where
right
you
back-
working?
I was CCS Construction. I went right back to my job January 8th, man. I worked every day, Friday and Saturday. I work with my father, doing work with him, man. I don't have no time to BS, man. That honey pack situation, man, the meth situation, Your Honor, you can tell it only popped in my system one time. Out of all the times I didn't drop urine for Miss Crook, it only popped in my system one time. And the honey pack situation, I met a new lady female. Well, first of all, let me just explain. I moved into my apartment. I got out. I signed my new lease.
Where's your apartment?
On East 222nd Street, 397.
All right.
Kenwood Crossings. I moved in there January 15th. I signed a 1-year lease in my name. Remember, me and my son was staying with my mom for 4 years. I was a blessing. I got my own apartment,
Okay.
man. So I met another young lady, man, and I'm sober, man. Usually, like, to keep it real with you, man, I met a young lady, man. She came to my apartment, man. You know, I wanted to have a sexual encounter. You know what I mean? I went to the store, the car gas station on 200th Street, man. I went to get a honey pack. You know what I'm saying? The A-Rap guy in there say, man, we got some new shit. I got new Viagra pills in here. I got $7 pills, I got $5 pills, I got $10 pills. I said, boom, give me the $7 pill. The honey pack is a sexual enhancement. I'm sober, man. I ain't want to have, you know what I mean? Sober sex would have been 4 or 5 minutes, man. And that's the honest to God truth. You know what I'm saying? It was my first time meeting the lady. It was the first time in depression, man. So I got the Viagra. I didn't know the Viagra wasn't real. That's the only thing you can tell. I don't do no meth or none of that, man. I go to work. You know what I mean? I take care of everything I'm supposed to do. I got 6 warrant blocks paid down. Get my license, man. I paid all the warrant blocks down. I got like 2 more left.
What blocks remain? Is there one in Euclid?
No, Willie B. Hills and Shaker. And then them met with the Attorney General. Every week, Jamie made sure she told me, man, Mr. Glenn, you come here and see me, Pat had to have a warrant block issue paid off. Every time I got paid, I come and see her, I pay off a warrant block, man. I'm down to 2 more warrant blocks, man. Out of all them warrant blocks, I'm down to 2 more. I didn't work this hard to come this far and lose, Your Honor. To lose everything that I worked hard for. You know what I'm saying? I didn't come this far to lose, man. It was knowingly, yes, it was knowingly, but hey, I bought the shield from the A-Rab at the Clark Gas for 200. Was it a good idea? Probably not. But at that time, I wasn't thinking that it was a fake pill. I wasn't. I was just had sex.
Why did you go to Clark gas station that day?
Because I went to get a honey pack. A honey pack is a sexual enhancement.
How did you know what that was?
A honey pack? Because I didn't use them previous times before.
Right.
It's a sexual enhancement, sexual stimulant, man. You know what I mean? Usually,
you probably ought to get that from a doctor, not a.
And you're right. Like I didn't think about that at the time. You know, I didn't think about it at the time. You know, I mean, every store sell them, so it's like, you know, usually I just go. I mean, usually before I'm on probation, to smoke weed and I drink. You know what I mean? But it was like.
Tell me what work you do.
I do construction, heating and cooling. I make $32 an hour, man. I got a great job, man. I talk to my job. You know what I mean? If I can get out, go right back to my job tomorrow, just like I did January 7th.
When did you get arrested on this one?
March 5th.
Okay. Where at? At probation?
Yes, sir.
All right.
And that day I came in, I had a warrant block release East Cleveland. I paid off. I didn't come this far just to lose. You can tell if Your Honor, and to be honest, be truthful, honest with you, I've been in the system since 2000. I'm not gonna knowingly take a drug that I know that I took and walk in and give Miss Crook a positive urine sample. I'll do anything to come back the next week. I'll give her any type of excuse or reason. I'm not.
When's the last time you smoked pot?
Last time I smoked pot was, honestly, man, the day I got out, January 7th, man.
The day you got out?
January 7th, that was it.
Why did you do that when I let you out?
I didn't know. It was a dumb thing, but that was the last time I smoked pot, Your Honor. I'm keeping it real. That was the last time. I haven't smoked since then. I haven't smoked since then. The only addiction I got is cigarettes, man. I be in here because I know you can't. I don't smoke weed because this is what happens when I get in here, and I can't smoke no weed in here. I don't crave that shit. Excuse my language. I don't crave it or nothing, Your Honor. I'm not going.
Did you ever crave it?
No.
Then why'd you smoke it?
It was stupid. It was dumb, man. Honestly, for real, it was a little one I had in my ashtray, man. Like, I just got that news about, remember when I told you I just got accepted to my apartment? I've been staying with my mom for 4 years, man, me and my son. You know what I'm saying? I've been staying with my son for 4 years, man. I finally got accepted to my own apartment, man. You know what I mean? And I was happy, I was joy, man. It was a little piece that I still had left, man. But that's the last time I smoked pot, Your Honor.
Who's watching your son now?
My mom, she getting, but shit, since I've been, excuse my language, since I've been in jail, I spent $200 on phones just to make sure I can get my son a ride from school, because he got school at 4 o'clock. My mom, she do home health aid. She works, she watch a 100-year-old lady. You know, my son, mom got killed in 2024 in a car accident. That's why I be so emotional and all that over here. I'm not gonna risk everything I worked hard for, man, over a drug that I really didn't know when I took. If I was addicted to it, it'd be in my, I'd have dropped urine for it more than once. It was that one time, man, I went to get a sexual stimulant, Your Honor, that's it. I'm not gonna knowingly walk into this place.
You spent
On the phone calls, man, since I've been in here, I had $300 in my head. I got paid that Wednesday, that Thursday. I got off work at 2 o'clock that Thursday, March 5th. I went to East Cleveland, paid a warrant block down, and I came back there. I went to see Jamie right after that, and I had $300 in my account, in my pocket. I had $304 in my books in here. I got $55 now. I spent $75 on commissary, and the rest was on phone calls, man, just to make sure I can get my son a ride from home from school.
All right, so what I was saying is you spent 20 years being a pain in the ass, right? In and out, in and out.
And that's why I know better. I know better. I'm not gonna come in here and give her a positive urine sample. I know better than that.
Let me go.
I'm sorry.
Up until 2019, when you got out, when did you get out of prison? I got April.
2019, July, 4th of July.
Okay. And then you got, is it dinner time?
It's a swamp leader,
Then you got some marijuana charges since then, and then you get this, okay?
No, it's been clean. I haven't did nothing, man. All I do is want to do work and do for my son. That's it. That's it, Your Honor. I just want to live my life for it now, man.
Okay. So,
On my daughter's grave, man. My oldest daughter got killed 2022, man. I don't even swear on her, man. That's how serious I am, man. On my daughter's grave, man. That's why I'm so protective over my son. I already feel like a father. I didn't protect my daughter, man. That's all I do, man.
all right, so you got an apartment, you got a good job, you got custody of your son.
Can I add something to the record
Yeah.
before I forget? When the probation officer reminded me of this, when we were here on January 5th, the issue of the rehab program came up. And I was asked to get those records for when we come back, which now is today. And I do have those.
Okay.
So I can, and it's
That
quite
was
extensive.
an IOP?
Yes, I
Yeah,
completed that.
I can give this to Derek before he
I
makes.
completed that, and I'm 2 courts away from getting my license. I want to get my license that way,
Okay.
because I want my heating and
So
cooling.
I was in the midst of saying the things that you've done, okay, and you're close to getting your license, so stay out of the Arab stores, gas stations, getting that
Oh, I'll
shit.
never do that, never
Okay.
do that again.
Stay away from the pot. If you're playing around with meth, stay away from the meth,
I'm not.
okay? Then it shouldn't be a problem.
It should. It won't be a problem. I promise it won't be a problem, Your Honor.
So I shouldn't see you again,
You wouldn't.
is what you're
Next time
telling
you
me.
will see me is hopefully when probation get terminated, whenever that is.
Well, I put you on for 4 years, a little more than 2 years ago, so you got 2 years left. Now, when you were,
Can it drop down from once a month?
when you were here, in February of '24, I told you gotta do the IOP and follow recommendations. Apparently you've done that.
Yes, sir.
To get a job, you've done that. To get
Yes,
a
sir.
license and clear warrants, you haven't done that, but you're getting there.
Yes, sir.
So, the only one who's in your way is you, so
Yes, sir.
stay out of your own way,
Yes, sir. Thank you.
all right? So you've been in 20 days, is it 20, Derek, or 21? Do you know? The 5th? 20? So I'm gonna keep you on community control, 20 days credit for 20, and complete the things you haven't completed yet. God damn it, quit coming back here.
I am, Your Honor.
And then give those to Derek, I guess, and he'll give them to Jamie. When does he need to report upstairs today, or is he gonna just come back next time to Jamie? Do you know?
I'd say come in when you get released.
Go to probation when you get released, and then you'll come back on your regularly scheduled days.
Come in today?
Yeah, when you get released today, go up there.
Okay.
Is she here today, or is she not?
She's not.
Okay, go up there anyway.
Can I ask a question, Your Honor?
Yeah.
All right, now you gave me 4-year probation. It's been 2. Do I still gotta come every week, or can I get?
That's up to Jamie.
Okay.
What day do you come?
Every Thursday. That's what I'm saying. Every Thursday. I see every Thursday.
Okay. Then, had you been reporting every week?
Yes, sir. Yes, sir. I come every Thursday, and like usually, sometimes, most of the time, I'll be having to. It depends on where I work at. I might have to leave work a little bit earlier.
Okay. All right. As of now, you got to do what Jamie.
Okay. I will do.
As you do.
Thank you, Your Honor.
Derek, anything else? Mr. LaConte, anything else?
No, Your Honor, thank you.
All right.
I'm gonna release it then?
Yeah.
Well, that was entertaining, as it often is there. Alrighty. Let's go back to Judge Aquilina, new contestant there.
Michigan versus Jeremy Barber. Counsel, your appearance for the record.
Good morning, Your Honor. AP Wilcox on behalf of the People's State of Michigan.
And good morning, Your Honor. Frank Harrison, the Ingham County Public Defender's Office, here on behalf of my client, Mr. Barber, who appears in person and standing to my right. And if Your Honor would allow me to approach, I have the plea sheet.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Will you put your hand down? Have you taken any medication yesterday or today?
I do.
Okay. Is there any medication you're supposed to be on that you're not on?
No, actually, I'm working with CMS to get out everything I need to be on. So.
Okay, so is the medicine you're supposed to be on possibly, or is the medicine that you're on, does it interfere with your ability to understand us? All right.
Finish the question before you answer.
Sorry.
Okay, so you're feeling okay on the medicine you're on? And what about the medicine that they're working on, maybe getting you on? Is that causing you any issues in terms of understanding anything?
No.
Okay. Any sign of fever, COVID, or other illness?
What was that?
Any sign of fever, COVID, or other illness?
No.
And you spent enough time with your attorney in regard to what I understand is going to be a plea?
Yes.
All right, thank you. On behalf of the people, what is the plea agreement?
Yes, Your Honor. The defendant we plead to count 1, controlled substance possession, cocaine, heroin, or another narcotic less than 25 grams. Upon successful plea and sentencing, the habitual offender fourth notice would be dismissed. Additionally, Your Honor, there is a kill of written agreement to county cap.
Full, fair, accurate, and complete?
Yes, Your Honor.
All right, thank you. And I'm sorry, he's going to be pleading to count 1?
Count 1.
All right. All right, and then, sir, is that full, fair, accurate, and complete?
Yeah.
All right, now, so the reading of the.
Yes, Your Honor. People of the State of Michigan versus Jeremy Michael Barber. State of Michigan, County of Ingham. In the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 1, controlled substances possession, cocaine, heroin, or another narcotic less than 25 grams. On or about November 30th, 2025, at East Cesar Chavez Avenue, at North Washington Avenue, Lansing, Michigan, 48906, Ingham County, State of Michigan, the defendant did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance cocaine, contrary to statute. This is a felony that is punishable up to a maximum of 4 years and or $25,000. Court shall order law enforcement to collect DNA identification profile sample before sent to the disposition, if not taken at the time of arrest, and against the peace and dignity of the State of Michigan.
Sir, did you understand what was just read?
Yes.
So you understand count 1, possession of a controlled substance known as cocaine less than 25 grams is a felony punishable by 4 years and or $25,000.
Yes.
And it looks like you signed the advice of rights form.
Yes, sir.
Did you read it before you signed it?
Yes, sir.
Did you understand what you read?
Yes.
If you had any questions, was your attorney able to answer those?
Yes.
Do you have any questions about your rights at this court?
No, I do not.
And sir, are you a U.S. citizen?
Yes, I am.
And are you generally gainfully employed?
I'm self-employed, taking care of rental properties.
Okay, and you're able to make a living from that?
Yes.
At the time of this offense, were you on probation, parole, or bond conditions?
No, it was not.
All right, and when you came in contact with law enforcement, were you high?
No, I was not.
Okay, so, you remember the events of the day?
Yes, I did.
All right, very good. Sir, as to count one, possession of a controlled substance known as cocaine less than 25 grams, how do you plead?
Guilty.
And sir, do you understand that you are also giving up your automatic right to appeal? If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal.
Yes, sir.
And you're giving up the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to choose to provide a defense, to remain silent, to ask the court to bring witnesses, all of those rights you're giving up.
Yes.
And you decided to plead after consulting with your attorney?
Yes, I did.
And you've been satisfied with your attorney?
Yes.
And you pled of your own free will?
Yes.
Now, sir, there is a county cap on this, that's part of your agreement, so if I violate that, I'll allow you to withdraw your plea in this manner, would again go to the pretrial stage. However, if you violate the law or bond conditions between now and sentencing, I don't have to honor that, I could send you to jail or prison, and would not allow you to withdraw your plea. Do you understand how that works?
Yes, I do.
Has anyone told you, other than the sentencing agreement, what I'll do with sentencing?
No.
Because I don't know, I will make up my mind after I'm fully informed. Do you understand that?
Yes.
Sir, did this event occur on or about November 30th, 2025?
Yes, I did.
In the city of Lansing County, Bingham, state of Michigan?
Yes.
At a specific location known as East Cesar Chavez and North Washington Avenue, you came in contact with law enforcement?
Yes.
Were you in a vehicle, on a bicycle, walking, or something
I was
else?
in a vehicle.
Driver or passenger?
Driver.
And why were you pulled over?
Sitting on the windows and no proof. The plate came back as the car didn't have insurance.
Okay, and so officers pulled you over.
Yes.
Did they ask you to step out of the motor vehicle?
Yes, I did.
And did they search you, the vehicle, or was the cocaine in full view?
No, they asked to search the vehicle and I gave them permission to search the vehicle.
And then they found cocaine?
Yes, they did.
Where was it located?
They found it back behind the back passenger seat of the truck vehicle.
Had you placed it there? Did you know it was there?
After the fact,
After the fact, but should you have known it was there? It's your vehicle.
I mean, it wasn't my vehicle, but I know I was driving the vehicle, so whatever was in the vehicle at the time of me driving it, I was responsible for it. So therefore, I'm taking the responsibility of it being there.
All right,
It should have been my responsibility to search the vehicle to make sure there wasn't nothing in there that should have been around at the time anyway, so.
all right, and you didn't have any license or special authority or permission to have that cocaine, is that correct?
That's correct.
So, sir, were you using cocaine or were you with people who were using cocaine?
Somebody was around me that used cocaine.
Okay, so you knew there was a likelihood that it could be in the vehicle?
Yes. I mean, not really. I was in the process of moving at the time and my little brother was helping me.
You're gonna have to decide if you want this plea or not.
Yeah, I'm going with this, but yes, you're right, yes.
So you have to take responsibility for being.
Yes,
in the car.
I did take, it is my responsibility, but I already said I take complete responsibility for this situation.
You're okay. On behalf of the people, was it tested out to be cocaine?
Yes, sir, there was a true narc to be found positive for cocaine.
Is there any other additional information you would like placed on the record for the factual basis, given this circumstance?
Mr. Barber, were there also capped and uncapped needles in the vehicle as well?
Yes, it was.
And you were aware of those needles?
Oh, yes, it was.
And so therefore, it follows that you were aware of the cocaine found inside of the vehicle, correct?
Were those needles related to cocaine or other substance abuse?
Those are for, I'm actually a heroin addict, and I work with needle exchange to help people on the streets to have clean stuff. Then I exchange them. I have a red box, usually that's in the vehicle with me. It just wasn't in there that day. To put them in there, we're in the center console. I have the card. I mean, that's what I do is I try to look up for the next person because I was thankful and blessed to get the help that I had got from a 7-year strike of heroin with the chance of drug court and people being there to help me. So I try to help other people, but at this point in time in my life, I see that it's in my best interest just to stay away from it all and let them do them and me continue to move on so I can be there for my grandkids.
When you were arrested, did they give you a drug test?
No, they did not.
If they would it have been clean?
Been just dirty for marijuana.
Your Honor, I don't think we have a factual basis at this point in time because he's not saying that he knowingly or intentionally knew that there was a controlled substance.
Unfortunately, I would agree, Your Honor.
I would agree. This is problematic. Sir, don't take the rap for something just to get it over with because sometime in the past you did something or you're trying to save somebody else from charges. I don't really know what's going on here.
I mean,
You are
Mr. Barber, we already made
trampling, you're trampling on your own constitutionally protected right to go to jury trial and to have the people meet their burden. I'm not sure they can under this. I don't know. You talk with your attorney, but I'm not accepting this today. I appreciate you wanting to take accountability. I so rarely see that, but sir, I don't think I can take this plea right now.
I would agree. I just thank you, Your Honor, for your consideration today. We'll
yeah.
just.
Send this for trial.
Thank you, Your Honor.
Judge Jason Elmore, take note. That is an example how in the state of Michigan, yes, as a judge, you can indeed reject a plea deal. If you watched Sidebar last night, you know exactly what I'm talking about right there. Okie dokie. Let's head back over to Judge DiSanto.
Morning, Your Honor, John Goldpaw, P 30758 on behalf of Mr. Mascai. Mr. Mascai, please put your name on the record.
Louis Mascai.
Okay. Is there a reason, sir, why you're dressed as though you're just going to the gym?
No, man, this is the attire I have. I don't have no dress clothes on.
Well, sir, there's ways that you can still appear appropriate and even grab something from the thrift store or something. I'm not sure. But why do you have your child here with you, sir? Is that your child that's with you? Isn't there a little girl that's with you or a little?
Yes, my daughter.
Right. Why do you have her here in court?
That's my wife came with me today, ma'am.
Okay, well, I'm gonna have your daughter stay outside. It's not appropriate for her to be inside here. How old is your daughter?
4.
4, right, that's not appropriate for your daughter to be here. Ma'am, if you can take your child outside, please. All right, today's the date scheduled for sentencing in this matter on your client's plea to a guilty to, or no contest to aggravated assault. The assault and battery was dismissed by way of resolution between counsel. We have Mr. Cunningham present, and then we also have another individual, Ms. Hagerman, present as well on screen. Mr. Cunningham's in person, Ms. Hagerman is here on the screen. There was another individual named Ms. Hillier, but I don't believe that she's been present or that she's present. Counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, we have, Your Honor. As to the recommendation, we did have an opportunity to go over that. As to his employment, Your Honor, as is indicated here, Mr. Mascai is presently earning on unemployment. The reason being is that he works landscaping and he is not scheduled to return to the landscaping job until the end of April. Seasonal, that's when they pick up. Other than that, Your Honor, also he is still helping, working out, but I won't say under the table because he's a barber. He doesn't work as a barber anymore, but he does pick up extra by doing family members, etc. Other than that, Your Honor, there are no additions, deletions, or corrections to be made. I do read this, going over the documents that were attached regarding request for restitution. Mr. Cunningham, I'm sorry, documents that were presented appear to be, I'm just making part of this, something from the hospital or from an insurance company. I don't know if this was out-of-pocket expenses to the victim in this particular matter. But I've also spoken to Mr. Nasguy and realized that he had no intention to harm Mr. Cunningham. This was a reaction, and that when he pushed him, he had no intention of causing any injury to him, though the plea obviously was to the aggravated no contest.
Okay, excuse me one moment. Sir, what did you think would happen when you pushed an individual?
Well, ma'am, he approached me, Steiger, screaming and cussing.
No. Before we get to that, that's because there's something before that.
No, it was a push, like.
Stop.
Get out my face.
Just one moment. Had you not pulled your vehicle over and gotten out of your vehicle, none of this would have even occurred.
Same for him.
So, no, it's not the same for him. He had pulled over to go to a yard sale or wherever he was going.
He ran me off the road, man.
Sir,
Okay, I'm just, okay.
what did you think would happen when you put your hands on someone to push them?
I don't know, man.
I don't know, it doesn't work in this court. What did you think would happen?
I was just trying to get him out of my space, man. That's it. I didn't intend on hurting him. I didn't intend on him falling. I didn't intend on none of that, man.
No, I hear that. That's why I'm asking, what did you think would happen when you pushed him?
That he was gonna get out my face. That's it, man.
Okay. You may continue, counsel.
I was just indicating he realized this was the wrong thing. And of course, the wrong thing was to even stop there. I agree with that. He understands that now. At the time, he clearly didn't and wanted to resolve what he believed.
So, man,
Address the quick, and then you can talk with all you want.
I will never stop. My daughter hit me out the window, sir.
Okay. Then
I mean, that's all it was.
You had your daughter with you?
Yes, my daughter was in the backseat, man. I had another, I had my.
Hold on. So I just heard you say to your attorney that your daughter hit her head off the window.
Yes, she was in a car seat. She
She was in a car seat.
Yes.
If she was in a car seat, how did she hit her head on the window?
A 300 is a small compact car. Her car seat's tucked to the window. When he ran me off the road, man, I hit the curb.
Hold on, sir.
I hit the curb.
What? Hold on. What type of car seat was your daughter in?
A full car seat, man.
A full car seat,
Yes.
right? And the full car seat has the pieces of the
Yes.
of the headrest that go out.
Yes.
So your daughter wouldn't be able to hit her head on the window.
Good. I'm sorry.
On the window.
It's a booster seat, ma'am.
Well, see, now that's something different. A booster seat's different from a car seat, a full car seat.
Right.
You just said it was a full car seat.
Right, a full upright booster seat. She's 5. She's turning 5 now. She's almost 5 at the end of this month, ma'am.
So she was 4
Yes,
when this happened.
yes.
Okay. So your daughter was with you.
Yes.
The victim pulls off down a certain street.
He pulls over. Cause they have it in front of the yard sale, ma'am. This is exactly what happened.
Well, when I read the report, it showed that he turned.
I turned off of 6th Street, ma'am. I live off of 6th in Hudson. So that's how this was happening. Picking on my daughter.
I don't want, stop, please stop talking. Mr. Cunningham was going to a yard sale on Goddard Road. Mr. Cunningham was going to make a left-hand turn off of Goddard onto Lindbergh. But the red passenger car drove by quickly. That's your car, correct, sir?
Yes.
Okay. So he pulled off, Mr. Cunningham pulled off of Goddard Road onto Lindbergh Street and parked at the corner of Lindbergh and Goddard. So when I say he turned, he pulled over to the yard sale. Because that's where the yard sale was. As he was standing outside of his vehicle, he heard a male yelling. Then he saw, whether it was you or not, then he saw the red passenger vehicle stopped a couple houses west from where he was and you were on Goddard Road. Right?
Yes.
Okay.
But I had just made a left-hand turn off of 6, and that's where the yard sale is. The yard sale is on Achilles.
Sir?
Okay, well, I can speak.
My point is that Mr. Cunningham pulled off to go to the yard sale. You were on Goddard. You pulled over. After Mr. Cunningham turned, you pulled over because you were angry and upset.
But he was the one cussing.
Sir, I'm talking about you.
But I was
You were angry and upset. You left your daughter in the car.
with my brother. He was there.
Sir,
Ma'am, I'm being.
you walked to the person that you were angry with.
No, he approached me. That's the thing. That's in my report. He approached me. He came to me cussing at me. When he got to my nose to nose with me, ma'am, I just pushed him back out of my chair.
Sir.
That's all I did, ma'am.
You're missing the entirety of my point.
Okay, I granted, but he wasn't going to the yard sale.
The entirety of
Goddard.
The entirety of my point is that you never should have pulled over.
Okay, ma'am, I already admitted my faults. I admitted I'm wrong. Okay, I pushed him. I didn't mean to hurt him. I didn't have no intention to hurt him. I don't know him. It was a simple mistake. Okay.
No, that's not a simple mistake. Pulling over to get out.
To check on my daughter. And that's all I was checking to see because she bumped her head. Now, listen, this is the God's honest truth. When I got out to check on my daughter.
Sir, you live right in the area. Then you should have just turned back around and went home to check on your daughter.
I didn't.
No.
Exactly what I did. I took her right back to her mother, ma'am. I turned right back. That's what I put in my report. That's where they come to the house.
Okay, counsel, you may continue.
I mean, you're not even giving me a chance to speak like my side. Like it's just I already admitted my faults, ma'am.
Sir, what I'm hearing is a whole lot of excuses
Okay,
to justify your
okay,
behavior.
since there was no contact with the vehicles, I think he could have kept going straight too, and I could have kept going straight. That's it. We both made a mistake, and he approached me, and I did the mistake about pushing him.
Great. All right, what about the lady whose house you threatened to burn down and kill?
Oh, I didn't threaten no houses to burn down. Did anything? I've been on GPS tether for 6 months, ma'am. There ain't been no contact.
It was the same day.
My son goes to school at
Excuse me.
I haven't been back there. I haven't been to no.
It was the same date of the offense.
Well, they're all recorded, ma'am. They're all recorded me. Okay, anybody wants to be recorded, it was a simple mistake, ma'am. I didn't go back there.
Okay, all right.
Your Honor, and he's
Please stop.
denying that he made those statements.
Right.
All right,
It's not
so
part of it.
counsel, you may continue as to the PSI or on behalf of your client.
We've had an opportunity to review the PSI, Your Honor. We're asking that the recommendation is 24 months probation. Other conditions which I know the court will place upon him. There appears to be a request for restitution in the amount of $34.27. As I've indicated, the only document that I received or saw was the a hospital. It's a claims submitted by Downriver PLLC to Henry Ford Wyndham Hospital. If there is restitution, clearly this is not the appropriate amount. It's being requested. Since it's not being requested by Mr. Cunningham. Other than that, Your Honor, we're asking for recommendation.
What I'm going to indicate is that even just reviewing the police report, right? Individual people that don't even know Mr. Cunningham, I don't know about Ms. Hagerman. Multiple people stated that your client rushed over to Mr. Cunningham.
I understand what the reports say, Your Honor.
All right, so I'm going to give Mr. Cunningham an opportunity to address the court as well as Ms. Hagerman.
Your Honor, as to Ms. Hagerman,
Counsel, I'm just going to find out who she is and what she has with this case. That's what I'm going to do first. Ms. Hagerman, can you please unmute and state and spell your first and last names for the record?
My name is Barbara Ann Hagerman, BARBARANNHAGERMAN.
All right. And so are you a named victim, ma'am, or are you here to observe?
I was actually in the car when all of this occurred. We were going to a yard sale down Goddard Road.
Hold on, ma'am. Hold on. My question was, are you a witness or are you a victim?
I'm a little bit of both because he threatened me at the yard sale, and I would like to make a request that he is to stay out of the city of Trenton where I live. I have a handicapped daughter that I cannot move around the house fast enough. She has no legs.
Ma'am, just a moment, please. Just a moment. Okay, I'll address that shortly. And so my question was because there's an individual at a property that that was alleged to have been threatened. So I was just checking to see what Ms. Hagerman's
So if you let me explain, I'll explain exactly how it happened.
Ma'am, I'm not, we're not doing that right now. That's not how this works right now. All right, we're here for I'm just giving you information about the procedure. We're here for sentencing. Mr. Mazguy has already pled no contest. Mr. Cunningham will have an opportunity because he is a named victim. Ma'am, are you smoking?
I'm a little upset right now. I'm sorry.
Ma'am, you are in court.
I put it out.
In court. You are in court. You do not smoke when you're in court. I'm removing you from these proceedings. Absolutely not. Is that happening? No way. Mr. Cunningham, you may step forward and you may address the court. All right, and sir, if you could please state and spell your first and last names for the record.
My name is Tracy Cunningham, Tracy Cunningham, Cunningham.
Very good, thank you. Autumn, if in the event that Miss Hagerman zooms back in, she's not admitted in. All right, sir. And so you're the victim in this matter, and you've also submitted some restitution requests, but you do have the opportunity to address the court, and so you may proceed, sir.
I do. First of all, I'd like to thank the witnesses who were kind enough to take a picture that day. I was knocked out in the street, and I'd like to thank the detectives. I would like to thank Mr. Muhammad and the court advocate as well. And I'd like to thank Your Honor. The first time I got a chance to see you, you took the opportunity to read the case. That meant a lot to me. That during that first day, it was a minute and a half of silence that you actually took the time to read what really did happen. And I'd like to tell the court I'm right-handed. And the brief situation, what you heard, I was knocked out a few feet from my car, and his was parked way down the road. So you already know when the police report happened, came to me. I never swore at anyone. I'm a retired school teacher, and the language he was using on the African American that day, the only two phrases that were said
to Mr. Mescal were, I'm not a fan of the N-word, and when he went off on that gentleman, all I said, I avoided the accident from his speed. He said he was right off the road. He was speeding. I hit the brakes and avoided that turn from Goddard to Lindbergh. I avoided it. And when he passed, I assumed he had passed. So I went and parked and was headed to the art sale. It was 5 or 6 steps from my truck. So how could I have gotten his space? But he was parked further down Goddard. He ran past, threatening them. You know, they called the police. He could blow their house up, using the N-word to the next couple gentlemen that was there. And when he came to me, all I said was, we don't need that language. I'm not a fan of the N-word. I taught in Detroit. And I said, you were flying. You need to slow down. He punched and hit me in the chest. I fell back. My wrist was broken in 2 spots. I might have had extended therapy. My therapy's I've only had 5 weeks physical therapy. This is 7 months and I'm still in therapy. My elbow is, I'm more worried about my elbow than the wrist that was fractured. I've maybe more issues with my elbow. Even though the incident happened in Wyandotte, and I apologize for my gal, we've been together 17 years. Her concern that day, even though I was hurt in the hospital, was his threat of blowing if the police were involved. We have a handicapped daughter. That's why she's nervous and upset. She's a double amputee and she's on dialysis. That's what she would wear today. We can't get, she's on dialysis 3 days a week.
Your gal or her daughter?
Her daughter. Her daughter. Okay. She's needs constant care. So even though you had mentioned Wyandotte, her concern was that Mr. Mesguy, I mean, he took the point to walk all the way around the block to me, to hit me and make that threat. She felt that if you can please include the city of Trenton, that's where we reside. People always mention Wyandotte when at your proceedings for him not, even though he said he's a landscaper, that he not return to Wyandotte. We reside in Trenton. If you would just include that, because she's just worried about not so much herself as that if she would be able to wheel. The gentleman's behavior that day is scary. To hit a 60-year-old man for no reason. I met him, didn't know him. I didn't get in any, I was walking to a yard sale. I didn't even know what he was going to do. I was happy I avoided his accident from speeding. And my only solace out of this, Your Honor, is, well, first of all, with the restitution. The attorney for Mr. Mesguy is incorrect. This was sent to me by my insurance company that they weren't going to pay. I can give it to you, it's original. This is what they said they wouldn't pay. So that's the only thing I had to give the courts was my insurance, for whatever reason, said they were not going to pay it. You could call insurance line, that was sent to my address. That was my emergency room visit that day that is not covered. I don't know if they consider road rage or it's auto. I don't know. All I know is I had medical coverage, ma'am. I submitted it and they sent that back to me saying they weren't covering it. So I don't know what else I can provide the court that was sent to me. And my own solace, again, I'm thanking Your Honor, is the first day that you were questioning Mr. Mesguy and you were going through his record and he kind of smugly said he's never been convicted of any crime. And you called out those words. I can now say to him, you are now convicted of a crime. And when he explains that to people, he can explain that he hit an elderly gentleman for no reason in a street, knocked me out, broke my wrist in 2 spots, and I'm still in treatment. 7 months later, I'm still in treatment. So I'm going to leave everything else up to Your Honor. I've been impressed with you. You felt me sitting back there and understanding that even though I've been there, you acknowledged it. That meant so much to me and my family. And we thank you.
Okay, and thank you very much for coming in today, sir, as well, and for addressing the court as well. Other than the 3427, is there any other out-of-pocket expenses that you
As far as I know, my physical therapy's been paid.
Okay.
So It's ongoing. I have not received a bill for physical therapy.
Okay. Okay, all right. Thank you. I'm going to give that back to you as well, sir, so that you can retain that.
A copy was given to probation department.
Very good. Thank you so much. Mr. Goldpaw, and you may have a seat, sir. That way, you're good. Mr. Goldpaw, I'm a bit confused. When did your client move to Wyandotte?
Right? My wife was like, she had an address in Wyandotte.
I'm not asking about your fiance's address in Wyandotte.
I didn't have an address in Wyandotte, ma'am. My address-
You said a few moments ago,
Be quiet, totally.
stop interrupting me.
Oh my God.
You said a few moments ago, sir, that you were coming from Sixth and Goddard because that's where you live.
That's where I picked my daughter up from him that morning. And I dropped her right back off.
I'm pretty certain you said that's where you live.
Ma'am. That's what I meant, ma'am.
Sir, your attorney has told you a number of times, don't talk when I'm talking. Because see the recording right there? That it can record one person at a time. Stop talking when I'm talking. You stated that's where you lived. You said, I live at Sixth and Goddard. That is what you said, did you not?
Yes, ma'am.
Okay. But you don't live there.
No.
All right. So tell me about your 3 warrants that you have, sir, and what you're doing to resolve those.
Well, I have a traffic warrant in Detroit, but I'm on GPS tether right now, so that's just a matter of payment issues. And right now I owe a $325 payment for no registration till Lincoln Park. And that's all it is.
Well, why haven't you paid it, sir?
Man, that's what's been going on right now. And I'm on a fixed income right now. I'm making $312 every $312 a week right now. $612 every 2 weeks until work starts back up.
Sir, don't you think that you would make more money seeking employment during the off season than you do on unemployment?
Yes, but I'm going back to work, man. I'm going back to work.
That's great, but then for 5 months, you're not working. You're receiving minimal income. So my question, sir, instead of waiting for unemployment to come and just collecting unemployment, it would seem that it would make a bit more sense for you to go get employment for even the 5 months that you're not working as opposed to collecting unemployment.
Well, that's a stipulation with unemployment. You gotta fill out applications every week. So I'm just waiting for a call, man. That's just what it is. You got a job search while you're on unemployment, so.
I understand that. And so you didn't get one at all. You didn't have anybody call you for an interview or otherwise. Okay,
I've only been on unemployment 4 weeks now.
okay. So, sir, these warrants are from June of 2025. And you've only been on unemployment for 4 weeks. So why didn't you take care of those back in June?
I went to jail for one of the matters, ma'am. And then I got out and I paid one to get my.
Which matter was that?
For the driving on with no proof of insurance. And then the other ticket was no registration, which that's what I owe right now for Lincoln Park, which is $340.
Which is for disturbing the peace.
No, that got dismissed.
No, it didn't, sir.
The disturbing the peace?
Sir, I'm looking at it right here. You have a conviction from September 26th of 2025 in Lincoln Park. And in fact, you have a warrant that was issued February 3rd of 2026 because you did not appear.
For a payment review, right?
I don't know what it was for. It says failure to appear. So let me just go through this in just one moment here. In 2025, sir, January of 2025, you have a conviction out of this court for disorderly conduct. All right, that was the charge. And you pled to disorderly conduct. And what was your sentence out of this court, sir? Did you have fines and costs or were you on probation?
Fines and costs, man.
Okay. Then, sir, you have in September out of the city V course, you have another disorderly conduct.
That was disturbing the peace now.
Disorderly conduct, disturbing the peace. They're used actually disorderly hyphen disturbing the peace is what it's showing in the 25th District Court.
I'm looking at the PSI, I don't see that, but I'm not.
Yes, it is. It's on the first page under criminal history.
On the third page,
First page, on the first page of the PSI under criminal history.
I see, fail to obey. An 03.
Yes, go to the last one, 2025. That's Lincoln Park, disorderly.
I think it's
disturbing the-
926.
Right.
Right, like that I see, but I also, I
Did
did
you
not
get the
see,
amended one? There was an amended one that was done that showed the wind out one.
no, I don't.
Okay, that was January 23rd. So what I see, sir, is this. This paints a picture for me. A picture of somebody that is continuing to be unable to control his emotions. You have a disorderly conduct in Wyandotte. Then you get one in the city of Ecorse, which is within the 25th District Court in Lincoln Park. That's why it's showing Lincoln Park. Then that's around the same time as you got the one in Lincoln Park. In fact, right before that is when Mr. Mazguy was victimized by you, sir. So what I see, sir, is an individual with escalating emotions that doesn't know how to control their emotions. That's what I see. You had zero reason to pull over. Zero. No reason to pull over whatsoever. And then not only did you pull over, you get out of your car and then you start walking up to Mr. Cunningham or to the area, wherever you intended to go. With such force, sir, that he fell backwards, fractured his wrist, did something to his elbow, and was knocked unconscious. With one time that you touched him, with such force. That was what happened as a result of your actions. You could be mad that he pulled out in front of you, he turned in front of you, whatever it is, sir. You have the right to be angry about that, frustrated, whatever it is. You don't have the right to act upon that anger in the manner in which you acted. None. Council, I asked for the recommendation.
I've indicated, Your Honor, the amount of restitution requested still doesn't show any out-of-pocket expenses to Mr. Cunningham. As such, until that is shown, restitution, I mean, who gets the restitution? Is my question. Is this a bill from the hospital?
It's a bill from his insurance. It's a statement from his insurance company that they did not cover that. So here's my question, counsel. If Mr. Mazguy doesn't have that money to pay out of pocket and he has to pay as he gets it from your client, I'm sorry, Mr. Cunningham, if he doesn't have the money to pay out of pocket and that one lump sum, then your proof of payment is not going to be there at all. So perhaps, and I don't know, maybe Mr. Cunningham has to wait until he's paid restitution by your client before he can pay that bill in full. I have no idea.
I understand that, Your Honor. This doesn't, and I just saw this, when this attached. This appears to be when he was put to the hospital, and according to Mr. Mazguy's testimony, this is rejecting the claim. It's not
Mr. Cunningham, so.
Mr. Cunningham.
Yes.
I don't see where this document says that.
All right. So what I'm going to, I'm going to direct Mr. Cunningham to just get something from his insurance company indicating that he is the one that's responsible for that balance. There you go.
Yeah, once we get that, then we can figure out the exact amount.
Great. All right. Anything else?
Other than that, Your Honor, Mr. Mazda, has indicated that we're asking the recommendation to be adopted.
Here's what this court's going to do. This court has serious concerns regarding Mr. Mazguy and the safety of this community, any community, quite frankly. Because Mr. Mazguy, as he's even indicated, doesn't even know Mr. Cunningham, yet behaved in this incredulous behavior for somebody he didn't even know, with his 4-year-old daughter in the car. And it's also clear to this court that Mr. Mazguy's behaviors continue to escalate. And so Mr. Mazguy definitely needs some assistance in managing that anger. The court's going to note, after hearing from Mr. Mazguy, Mr. Goldpaw, Mr. Cunningham, that in review of the report, the recommendation, the police report, the criminal history of Mr. Mazguy, the court does find that there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Mazguy. The court's going to order 180 days jail. The court's going to suspend 150. That means you're going to serve 30 days jail. The court's going to also indicate that upon your release from jail, you're going to be sentenced to 24 months probation. You're eligible for early discharge with a hearing. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to have any contact with the complaining witness in this matter, Mr. Cunningham or Ms. Hillier. I'm also going to include Ms. Hagerman, as she was in the vehicle as well. That's phone contact, text message, email, social media, third party, anything of the like. You're not to go to any of their homes or places of employment. You're not to possess any weapons or firearms. Do you have any of those, sir? I can't hear you.
No.
You are to participate in a 12-week anger management class. The rehabilitative goal for that condition is so you can further have an understanding and some tools whereby you learn how to properly manage your emotions when you are in an upsetting situation. And then the court's going to order mandatory jail for any violations. Sir, you're looking at your charge, your conviction is for up to 1 year in jail. All right. I have now sentenced you to 180 days in jail. That's half of that term at this point. And you're served 30 of those days.
No.
This behavior is not tolerated at all.
Yeah, can I ask a question?
What's that?
Can I have a little time so I can get this unemployment, a couple more checks for the van? Because I mean, I take care of the household, I'm the head of household. So can I have a date to turn myself in for the 30 days, ma'am?
So, sir, here's the thing, right? I'm not giving you a couple weeks. So it's not going to be a couple more paychecks. And if you're set to go back in April, that's next month, right?
Yeah, because I'm on GPS, so that's why I asked, ma'am. I'm still on tether.
I understand that.
So
But sir, this 30 days is part of your punishment for the behavior.
Your Honor, would you give him 1 week?
No, not give him 1 week. The most I will give him is till Friday. That's it. March 27th.
And he will go to Wayne County Jail?
Yes, you're going to go over to probation. You're going to get all of your next steps as how you go and report to from jail, sir. As it finds a cost, the court's going to order a $1,000 fine per statute. It's up to $1,000, $100 screening assessment fee, $1,200 supervision oversight fee. That's 24 months at 50 months. I'm sorry, at $50 per month. If you are discharged early for probation, sir, then up to half of that, or then the part that you're not on probation anymore, sir, that portion would be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. The court's going to order $3,427 in restitution upon the proof that Mr. Cunningham is responsible for that. So that's $2,725, then plus the restitution portion, that brings it to $6,100, approximately $6,152. You can set up that payment plan upon your release and return to work. Keep your hands out of your pockets, sir, please. Any questions?
Thank you.
That did indicate you're eligible to request early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation reports have been completed. You've had at least all probation conditions have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. Given that this is a large amount, sir, you just have to make sure you're making your payments monthly and timely and so forth.
Thank you.
Have a good day.
So you guys know how we kind of collect unique courts around here. You know, we've got hallway courts down in Georgia. We've got the fancy courtrooms like Judge Collada. We obviously have dungeon court where it's haunted and evil. We have court that's held in the converted pole barn. So many things. So I want to show you a court in Licking County right now. We're not going to stick around for any hearings because, to be honest, what's going on there at the moment is not all that interesting. It's just a small claims court. However, I would call this courtroom brought to you by the people who build tiny homes. Isn't this just a cute little room? It's so tiny. Desks that 2 people can barely fit behind. It looks like, at least from the camera angle, a fairly low ceiling. I kind of expect that the pews back there, the seating, probably pull out into beds. It just feels like it's just got this tiny home feel. So thought I would share, kind of unique. Let's do this. Let's go. Speaking of Ohio, not Judge Collada, but back to Judge O'Donnell.
Getting her treatment in place, including a plan we discussed in chambers, Your Honor. She is asking this court to grant that motion. She is prepared to enter a plea of information. I discussed the information 1 count charge with her, as well as the waiver of indictment to the Lake County Grand Jury. I anticipate that plea to be forthcoming today. She is competent to go forward. I see no other reasons why we could not go forward on this today. Thank you.
She's got 16 separate entries on her record. ranging from minor misdemeanors to misdemeanor ones. So why is this appropriate for intervention?
Yes, Your Honor, thank you. She recognizes that she brings to the table today these many misdemeanors that are in her past. She's hoping to rectify that. She has not yet somehow got a felony charge until this matter. So she has, at least before it's too late, before she overdosed or did something more drastic with her medical condition, has recognized a great need for treatment in this matter. To that end, she has been attending AA meetings. She has signed medical releases. She has, I think she started with Signature Health and has now moved on to Lake Geauga and formed a plan, which she will start an intensive outpatient treatment at the end of this month, Your Honor. She'd be willing to do anything additional that the court may order, including mental health assessment meeting with a psychiatrist or psychologist, taking any mental health medications that may be prescribed to her, as well as meaningfully participate in her treatment plan, Your Honor. She knows that the court does not have to grant this even though she qualifies for it. She knows the court could say, you know what, you can just do this all on probation and not get ILC. We know we're putting ourselves in the situation where we're asking the court, and it is a big ask, Your Honor, especially in light of her past. But again, she is 46 years old. She's got plenty of time to turn things around. She's been doing very well on bond, has not demonstrated that she is a bond violator, and I think this is a good indication for her future behavior. While her past behavior is of great concern to the court, I'd like the court to shift focus to her future behavior in light of the documentation that she's provided. She's been in contact with my office regarding the steps that she's taken. She's got support from her sister. She's gainfully employed at Chipotle, no issues there with her job. So she is contributing meaningfully to society. I don't believe she poses a continued danger to herself or others, despite the misdemeanor record, Your Honor. Thank you.
Mr. Knopf, as to the intervention request.
The state would not be opposed to the defendant being granted intervention.
All right, I will grant the motion for intervention. Ms. Kaufman, how old are you?
46,
How far did you go through school?
8th grade.
Are you a U.S. citizen?
Yes, I am.
Are you able to read, write, and understand the English language?
Yes, I do.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
Absolutely not.
Have you ever been diagnosed with or treated for any mental illness?
I was diagnosed with bipolar, but now I'm just being reevaluated and stuff.
Reevaluated by who?
Signature and Lake Geauga.
Did you get a copy of the information filed in this case?
Yes, I did.
Do you understand you have a right to have your case presented to the grand jury for them to decide whether or not to indict you?
Yes, I do.
Did you discuss that right with your attorney?
Yes.
And are you going to waive that right?
Yes, I do, Your Honor.
Go ahead and sign here, Amber. That's the waiver of grand jury that we talked about, so you can do your information plea instead of plea to an indictment. Okay. Your Honor, I have witnessed the defendant and defense counsel sign the waiver of indictment. With your permission, I will return to the bench.
All right, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, let me know. If you want to talk some more to Mr. Mulkey, let me know that, and I'll give you more time. Do you understand that?
I understand, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Your Honor.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
If you file an appeal, you have a constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, Your
Are you
Honor.
waiving that right?
Yes, Your Honor.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, Your Honor.
If you file an appeal, you're entitled to be given a transcript of all the hearings in this case. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your
If
Honor.
you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, Your Honor.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Your Honor.
Do you have any questions about any of your rights?
No.
Do you still
Your
want
Honor.
to plead guilty to this charge?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes, Your Honor.
You understand that by pleading guilty to this felony offense, if you are convicted, then you are voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, Your Honor.
Aggravated possession of drugs is a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, Your Honor.
If you plead guilty to the forfeiture specification, you're voluntarily giving up any item listed. Do you understand that?
Yes, Your Honor.
Do you understand that if you are convicted in this case, it could result in a driver's license suspension of between 6 months and 5 years?
Yes, Your
Do you understand a conviction would prevent you from owning or possessing a firearm?
Yes, Your Honor.
Do you understand that if you are convicted and sentenced to prison, that as part of your sentence, you might be placed on post-release control after you're released from prison for up to 2 years under the parole authority?
Yes, Your Honor.
If you were placed on post-release control and violated any conditions, the parole authority would be able to send you back to prison for 6 months. Do you understand that?
Yes, Your Honor.
If that violation were a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, Your Honor.
And if that were to occur, the maximum prison sentence for that violation would be either 12 months or the time left under post-release control, whichever is more. Do you understand that?
Yes, Your Honor.
Do you understand that if a prison term were to be imposed, you would be eligible for judicial release?
Yes, Your Honor.
If you are convicted, I could put you on community control for up to 5 years. If you violated any conditions, I could send you to prison for 12 months. Do you understand that?
Yes, Your Honor.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, Your
Has
Honor.
anybody promised you what I would sentence you to in this case?
No, Your
Do you
Honor.
understand that if you are sentenced in this case, I would not have to follow the recommendation of either the prosecutor or your lawyer?
No, Your Honor.
Do you understand that or do you
Oh,
not?
yes, Your Honor. I'm sorry.
All right.
Whoops.
Have you had enough time to talk to Mr. Mulkey before pleading guilty today?
Yes, Your Honor.
Has he discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice he has given you?
Yes, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
No, Your
Are
Honor.
you freely, knowingly, and voluntarily entering your guilty plea?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Mr. Knopf, if this case went to trial, what would the evidence show?
Your Honor, had the case proceeded, the trial, the state would have shown that on August 24th, 2025, in Little Lake County, Ohio, the defendant was knowingly in possession of drugs. Specifically, Little Lake PD responded to a call regarding the defendant experiencing a psychiatric situation. Officers arrived on scene and found the defendant nude with her arms wrapped around another individual's leg. The officers helped get the defendant into the ambulance, who was then transported to Lake West Hospital. Officers searched the defendant's bag and discovered suspected narcotics. Those narcotics were sent to the Lake County Crime Lab confirmed to be methamphetamine.
Mr. Mulkey, anything to add to those facts?
No, Your Honor.
Ms. Kaufman, did you hear what Mr. Knopf said, that the facts would show if the case went to trial?
Yes, Your Honor.
Are those facts true?
Yes, Your Honor.
All right, what is your plea to aggravated possession of drugs, a felony 5?
Guilty, Your
And
Honor.
what is your plea to the forfeiture specification?
Guilty, Your Honor.
Mr. Mulkey?
Gonna sign and date. Signature page here. Signature and then today's date, which is 3/25/26.
Your Honor, for the record, I witnessed the defendant and defense counsel sign a written plea of guilty. I'm now signing it myself. With your permission, I return to the bench.
All right, Ms. Kaufman, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes, please, Your Honor.
I'll accept the written plea of guilty. Defendant was present with Mr. Mulkey, advised of all the rights from the knowing, intelligent, voluntary waiver. She understands the nature of the charge, the consequence of her guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. Will accept her plea of guilty to aggravated possession of drugs, a felony 5, and the forfeiture specification. I will stay the criminal proceedings. The items subject to forfeiture are forfeited to the state. I'm going to place you on an intervention plan for 5 years. You'll serve 19 days in the Lake County Jail with credit for 19. You're to have no drugs or alcohol, and you'll be screened. You're to complete the IOP at Lake Geauga and follow all recommendations. You're going to undergo a psychiatric evaluation, follow all those recommendations. You're to go to only one doctor and one dentist and one pharmacy for any prescription medication. You're to take your prescribed medication only as it's prescribed and assign releases so probation can get your records from treatment providers. You're going to get a valid driver's license, maintain full employment, attend at least 4 AA meetings a week and get a sponsor, get your GED and pay the costs and supervision fees. Ms. Henley, any other terms you think are applicable?
No, Your Honor, thank you.
Oh, I'm sorry.
Ms. Kaufman, do you understand all the terms of your plan?
Yes, Your
Do you have
Honor.
any questions about the terms?
No, Your Honor.
If you fail to abide by the terms, the state will file a motion to terminate your intervention, and if I find you violated, I'll terminate the intervention plan. You'll be convicted of aggravated possession of drugs, a felony 5. Do you understand that?
Yes, Your Honor.
And then all those potential penalties that we talked about come into play. Do you understand that?
Yes, Your Honor.
All right, Mr. Knopf, is there anything further?
No, Your Honor.
Mr. Mulkey,
Yeah, just a question about the bond.
bond is released.
Okay, thank you,
Thank you, Your
Judge.
Honor.
All right, we're adjourned.
Okay, friends, I think we've got time to squeeze in one more for today. Let's do one more from Judge Aquilina.
This is docket 254848FH and 256862FH. People of the State of Michigan versus Terry Scarrett. Counsel, your appearance for the record.
Good morning, Your Honor. APA Barbucks on behalf of the people of the state of Michigan.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Garrett, who is standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
Thank you. Put your hand down. This is a final criminal pretrial, sir. Have you taken any medication yesterday or today? Used any alcohol or marijuana?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And you've had enough time to speak with your attorney?
I've had time to speak with him.
All right. And this, has there been an offer in either or both files?
And so, Your Honor, that there has been a change in circumstances in this case, Your Honor. As of yesterday, the people were informed and made aware of new criminal charges that Mr. Garrett has. I have given a copy of that police report over to counsel. What I am seeing, Your Honor, is it was charged yesterday for a new assault strangulation charge against the same victim, Your Honor, that's in 25-4848-FH. So, Your Honor, I believe at this point there would be a potential violation of the no contact order, as well as additional new charges being filed. The people are concerned, Your Honor, especially due to the fact that there is a no contact order in this other case, and that there's a victim, that there are the same exact charges, Your Honor. I will say that Ms. Klein, the victim on this case, is on Zoom at this point in time. And Your Honor, because of all of this, I believe that we need to adjourn the sentencing at this point in time to deal with the PA 53 violation that's listed here right now.
To adjourn sentencing, we're not sentencing.
Yeah,
We need to file
Adjourn the trial, Your Honor.
In final pretrial.
Yes, correct, Your Honor. I will say, looking at the trial docket, it is the last one on the docket on April 17th. But I do believe, based off of this police report that I've received and given to counsel at this point in time, I believe we need to have a PA 53 violation hearing in regards to these allegations, Your Honor. And additionally, I think that Mr. Garrett should be put in custody at this time until the PA 53 violation can be heard, as there are allegations that the defendant is having contact with the victim, but not only contact, but violent contact, Your Honor.
And Your Honor, Assistant Prosecuting Attorney Abby Pfeiffer, as well with the people, I was one who screened this case yesterday. The officers found surveillance video showing that the defendant was there at the scene where the victim told the police the crime happened, and where she told them shortly outside of that scene. So it corroborates her statements.
So let me ask you this. Setting aside the violation for a moment, was there any offer in this?
Your Honor, there was an offer that was conveyed. However, based off of these new charges that were just charged yesterday, there's going to need to be a reevaluation of that big offer.
Mr. Goodrich?
Thank you, Your Honor. Your Honor, I was alerted to this situation this morning. I would state before that this, the alleged victim in case here did also send a letter to the prosecutor's office in December recanting all of her previous statements in the matter. I don't know what's going to shake of this. It's my understanding that they're intending to file charges. I don't see in 54A that they have received those charges as of yet. I would ask the court to essentially hold off on doing anything to address his bond at this time. If they do file charges, he will need to be arraigned on that case, and we'll have a bond set on that case. That will not be a PR bond based on the fact that he is currently on felony bond in this matter. So, and if we were to proceed with some type of hearing on this matter, essentially he would be unable to defend himself because any admissions here would be used against him in the new case. So I would ask the court to essentially adjourn this out a while and let the matter play out in the district court if the prosecutor's office is going to file new charges down there.
Do we have the film available?
I don't believe that we have the officers detailed what they saw in it that they got from Ask Protection at the Meyer that was next to where it happened.
And to clarify, Your Honor, that there's evidence that there was film of him leaving Meyer, not with her. She was in a vehicle
outside of Meyer.
Outside of Meyer. And he was gone by the time the police arrived, so.
So does this film depict contact or just being at the same mire?
It corroborates that he was at that mire shortly after the victim says the incident happened. She went across the street to meet with the police for safety. It happened in the vehicle outside of Meyer because she was driving him there. And then he started strangling her, demanding money from her.
Okay, do we have the part, Meyer's films are pretty amazing.
Mhm.
Do we have, if they've captured the vehicle?
No, it's internal. It's the video of him inside the mire. They went and they confirmed that it was his face, his clothing that the victim gave.
Okay, but.
Again, that would be alone by himself in mind.
Okay, but if I had just understood you, are you telling me at some point he was in her vehicle?
Yes.
In the Meyer parking lot? Do we
I
have that
believe it was
film?
nearby the mire. She's able to get away. He gets out of the car and goes into the mire. She's able to get into her car and drive away to the speedway across the street where she meets with police pretty soon after.
To answer the court's question, there is no film of these two in the vehicle, in the Meyer parking lot that we're aware of at this time.
Correct.
Right, and did she seek medical attention? Were there bruises, et cetera, in the police report noted or not?
Your Honor, there was, she did complain of minor neck pain and there was redness found around her neck. I will say she did refuse medical treatment, but there was redness found around her neck.
All right, until this can be sorted out, you are remanded to the Ingham County Jail, no bond, and we will set a Public Act 53 violation hearing. It does appear for public safety and safety of the victim. And now I have 2 files, now I'm going to have 3 files. We'll get it sorted out. How much time do you all need to prepare?
Your Honor, the people have been in contact with the victim in this matter. I would say a week or 2 at most.
And Your Honor, we would ask that be indefinitely adjourned because again, we have a probable cause conference and a preliminary exam that haven't even been scheduled on these allegations because they haven't filed the charges yet. So we would ask the court to hold such a thing in abeyance indefinitely.
Are the charges going to be, are they drafted? What's the story with the prosecutor's office?
Yes, Your Honor, the charges have been drafted. After I was informed by Prosecutor Pfeiffer of these charges, I did go to the warrant unit and tell them to put this expedited. So the charges should be getting to 54A as soon as today, Your Honor.
I see
My understanding.
that the warrant was authorized and the case filed in district court yesterday, so likely going to be sworn to either today or tomorrow.
All right, well, I'm gonna set this for, I don't know how long it's gonna take, but let's try May 13th at 9:30. And then you can move that date backward or forward, depending on what's going on, so we can this case moving, and counsel, you certainly can file a bond motion if you so desire, but at this point, he is remanded. Regarding the PA 53 plus the other file, we're gonna set all the files on that date.
Thank you, Your Honor.
There's 25-4848FH and 25-6862FH.
Yes, and we will also have the new file set on that date along with the Public Act 53.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, you're remanded, sir. No contact, no phone calls, no emails with this victim. If I find that that's happening, then you will have no contact with anyone. Thank you.
Alrighty, friends, that brings it to a close for today. I hope you all enjoyed the show. I did. I thought we had some pretty good court and a lot less glitches today than I had the previous day. So hopefully hopefully you all enjoyed it. No In the Blind tonight. In the Blind will return on Monday, and we will be back on this channel tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you are a channel member. Thank you all for everything today. Again, I hope you had fun, and I look forward to seeing you tomorrow. In the meantime, go have yourselves a great Wednesday. Take care. God bless.